I told you 2 people were killed, 2 drivers were driving, and that's it. I didn't tell you about the drinking, about the racing, about the fleeing, about the suppression events, any of that. And why didn't I do that? Because as I was saying, we wanted people that were totally impartial when you come to this case. I didn't want an advantage. I didn't want them to have it. I wanted you to decide this case, as I kept saying, solely on the evidence and the law. And that's what I told you I was going to do. And I told you, hold me to everything I said I was going to prove. Everything. And I'm going to show you everything we proved and more. And also, I said to you, if we prove all of this, we're asking for all this money, are you going to hesitate? And every one of you, I asked that question because that was really what I was just concerned about. I knew the evidence was overwhelming. I knew the loss of the family was tremendous. I've seen it all. But I was concerned that people could come with open minds and really do justice, fair compensation for what these people have lost. So that's why I didn't bring any of it up. And when you heard the opening statement, I bet you're a little surprised. But wow, all this evidence. So let's go through it a little bit and let's talk about it. And I want you to remember that this case is about human beings, is about the safety of others. And when people make choices, bad choices, there are consequences and people suffer. And that's what this case is about. Choices that 2 little boys never came home to their family by choices made by Grossman, Mr. Erickson sitting right over there. They made those choices. And now the day of reckoning is here. They've been able to stall and delay, and here we are now, nearly 6 years later. And now we're at the day of reckoning for all of them. And when people race through public streets where families are crossing streets and during COVID, they deserve what they get. And that's what we're going to talk about right now. So let's, first of all, I want to go to a couple of the slides. And I remember I told you about it's a search for the truth. Because the purpose of the trial is to determine what is the truth and what isn't. When you read your verdict in Latin, dic means to speak, ver the truth. You will speak the truth of what these boys meant to this community, what this community thinks about people driving and drinking and drugs and racing and cover-ups and suppression of evidence and all of that. You're going to make that decision. I'm not going to be the one that's going to say how much you should give. They're not going to be the ones that are going to say how much you should give. But when defendants make choices that kill boys and leave a family shattered for the rest of their life, they don't get to decide. You do, ladies and gentlemen. You decide. That's why we spend all the time looking for fair, impartial jurors to decide this case. So what is the truth? I think it's pretty evident, but let's go through it a little bit. First of all, this is the verdict form. Did the court give those? Did the jurors get that already?
No.
Okay. The judge is going to give you these later. And these are the questions you're to answer. You only have to answer these questions, and then that'll be your verdict, okay? And I'm just going to go through, and then I'm going to break it down and show you what all the evidence is. Then I'm going to talk to you about the damages. Then I'm going to tell you about what the defendants told you they were going to prove. And then I'm going to tell you why punitive damages should be awarded to punish the defendants. Okay, so 4 parts. So here's the first one, just to show you quickly. So you have a framework. Negligence, we're going to talk about that. Because of the evidence, after all the evidence was in the case, there was a determination made. You don't have to decide. She was negligent. And her negligence caused the death of the 2 boys. So those are checked. You don't have to decide that. There's no dispute on the evidence. There's been a determination made after all the evidence. They have no case. So let's go to the next question you have. So those you don't have to answer when there's a check. So you go right to Erickson. Let's go to Mr. Erickson. Questions 3 and 4. Same questions. Negligence. Negligence. Next page. It's not a touch screen. Okay. Yes. Yeah. He was negligent. He caused it. Were they acting in concert together leading up to the fatal collision? Yes, I'll prove, I'll show you that. Peter Grossman, that's already checked. You don't have to worry about that. Let's go to the next page. The damages, and I'll explain that to you, how to do that. It's going to take some time, but I'm going to talk to you about it. Keep going. More damages. Keeping in mind that Nancy and Karim have wrongful death claims for the loss of the boys. Nancy Iskander has a claim for seeing it, viewing it, as does her son Zachary. So those are the claims in this case.
I'm sorry, Councilman. I hate to interrupt you, but I need to see your sidebar.
Okay. This has not been determined. You decide. I'll tell you how it's been determined beyond a reasonable doubt, but it has not been determined. So there was a little confusion. No problem. Let's keep going on. Back to where we were. Past the damages. Past the damages. All right. These two questions, 17, 18, are important. They have to be answered yes to go to the punitive damage part of the case. Okay? And I'll explain that as I go. And then there's one more series of questions, which I'm not going to spend too much time on it, but let's see it. Okay. The city of Westlake, dangerous road condition. They have to prove all, there's like 6 questions. I don't believe there's any evidence. I'll explain it to you. I'm not going to spend a lot of time on it. So let's go now to the evidence. Okay, first of all, burden of proof. What do we have to prove to what level? More likely true than not true. A feather on the scales of justice is enough. Just tip it ever so slightly, and we've met our burden. In other words, criminal case, beyond a reasonable doubt. Here, more likely true than not true. That's it. 50.1, 49. Okay, 9 out of 12. So you need 9 out of 12 on each issue, but it doesn't have to be the same 9. So somebody might not agree on one, it's a different 9 on another, and it's a different 9 on another. So you just need 9, and it doesn't have to be the same, okay? So each time you have 9, you move to the next question. So were the defendant's negligence? So I told you Rebecca Grossman's already been determined. Scott Erickson, let's talk about his negligence. Was there negligence? Did it harm someone? And was it a substantial factor in causing injury? I think there's no question, but let me tell you why. Number 1, negligence is a failure to care to prevent harm by acting or failing to act. Reasonable, careful person. You must decide how a reasonably careful person would have acted in defendant's situation, like Mr. Erickson. Was it reasonable to be speeding and going down the roadway and punching it to miss the car? No. Here we are in Triumphal. We're all back to the same location. So here's kind of just a little summary. I'm not going to go through all the evidence just to bring you back. I know you all know it, but okay. Keep in mind, this is a Tuesday afternoon in COVID in September. So Mr. Erickson, who has admitted he drinks every day for the last 10 years, I'm sure it's much more, but that's what he's admitted. He's out having cocktails first by himself at 3:30 in the afternoon. I mean, he wakes up, doesn't remember what he does, goes, starts having cocktails, waiting to meet up with Rebecca Grossman. So he goes to the Stone House. We don't know how many beers he has. He claims one, but there's no receipt, no proof, no nothing. His friend comes later, has another beer with him. Then they go to Rebecca Grossman, is at her friend's house having margaritas. 4:30 in the afternoon. She's out having margaritas on a Tuesday. Okay. 5:30, they meet up at Julio's and they have margaritas again. 7 o'clock, they leave. They race towards the house, and then they end up at the crosswalk. So that's what happened, basically. But how did it happen? Here's who investigated the collision. Hale, you remember him, the first witness, Orange County District Attorney. Scott Sheehan, LA County Sheriff. Mejia, LASO. Renee Castaneda. David Raymond, and Jeffrey Mutar. By the way, defense called no experts to counter any of them. None. And you know they fought everything they could. If they had some evidence that they would show that this wasn't true, they'd have brought it. Because they've still been denying responsibility, and they'll still get up here and deny responsibility. Still, to this day. So here's this animation from Mr. Castaneda. See Erickson up there, barely misses. Boom. All right. There's no question what happened. No question. So, just to orient you now, keep in mind, because of the speeds, Jacob's thrown here is varying to 75 to 90 feet something. And then Mark ends up 252 feet from where he struck at approximately 73 miles an hour in a 45 zone with people out. And then where's Miss Grossman end up? A third of a mile from the accident scene. That's the facts, undisputed. Next. Mr. Castaneda did 3 methods to come up with the speed. He used the speed at impact, 72.7. He used the peak speed, 81 miles an hour. 2 seconds before impact, she's going 89 miles an hour, and we all know.
Objection, Your Honor, this takes the evidence.
Sustain. He said 89.
81. Did I say what I said? What else? It's 81 miles an hour. She was traveling 73 when she struck the boys. 81 miles an hour, struck someone at 73 miles an hour. 73 miles an hour. We didn't hear anything to dispute that. They put no evidence on to dispute that. It's undisputed. 72.7 miles an hour. A 11-year-old and an 8-year-old boy were run down when they were speeding. That's undisputed. I invite counsel to come up here and tell you what evidence they have that that's not true. I want to invite counsel for Grossman to come up and maybe today accept responsibility. Accept, okay, I killed him. Nothing. Nothing. Next. The grill patterns on her Mercedes-Benz match up with his skin. The testimony, there's nothing else. And the injuries of Jacob were consistent impact from the right passenger corner Grossman vehicle and the fender trajectory. Undisputed. Sorry. Erickson, 80 miles an hour approaching the intersection. He claims 50 to 55. No one in the case says that but him. And we'll get to his credibility, which is 0. Okay? Even he wouldn't believe himself, and I'll show you that. He admitted he failed to yield to the pedestrians in the crosswalk. He was in close proximity, so the boys couldn't clear. He blocked their escape route, and remember I told you they were walking in the opening statement like ducklings all falling to them on? They were like sitting ducks. When Erickson went through there they were, and she just ran them down and kept going. Okay? Are you going to accept that in our society that you can run down someone in a crosswalk?
Over.
Are you going to accept this conduct to run someone down the crosswalk, then flee the scene after drinking on a Tuesday afternoon and taking drugs? That's going to be something you're going to have to decide. Does our society accept that kind of conduct? Is that okay?
Sustain.
Question admonition, Your Honor.
Okay. Sure is. You're not deciding for society, you're deciding on the law.
Okay, are you going to accept that? Because Mr. Erickson accepts that. Mr. Erickson admits he can come into court and lie all he wants. Lie all he wants under oath, perjure himself. And his lawyer asks his questions. And he lies when his lawyer asks him questions. And he's going to come in here and complain. Okay. Okay, Mr. Erickson. Next. This was a totally preventable collision. They went out for a walk and they never came home. And Mr. Erickson, he's down in Cabo and he's in Las Vegas and they're all over the place. But the Iskander family isn't like that now. This isn't how it is for them. It's not how it is for them, but he's over there looking fine. Smiling, going to Mexico, Las Vegas, playing golf on this alleged celebrity golf tournament circuit, which that's not true, but come on. Come in this courtroom, take this witness stand right here and lie to your face continually. Who would do that? Next. I'm in control. Here's the video with 45 miles an hour. Follow the speed limit. Let's try that on for size. Oh. And what was said about that? All right, first of all, we already did that. Scott Erickson. Speeding impaired, failed to yield the right of way, cut off the escape route, fled the scene. Fled the scene. And you're going to see a lot of instructions about fleeing, suppression of evidence, and I'm going to tell you about those. Clearly, he was negligent. Substantial factor. Was he a substantial factor? It means that you, a reasonable person, would consider that could cause the harm. No question. No question. And there could be more than one harm. Cause. It doesn't have to be the only cause, the sole cause, the exclusive cause. It has to be a legal cause. That's it. That's it. And when they get up here and they tell you they're not responsible, because they're going to deny it too, think about what evidence do they have? Where is their evidence? Scott Erickson, that's their evidence? Okay, clearly a substantial factor. Now, 5. This is an important question because this is what this case is really about. Are we going to accept conduct to let people, late 50s, go out drinking and just start racing through the streets? Who does that? Who does that in our society? Who does that?
Sustain.
Who goes out and drinks and at 50 some years old and goes up to 80 miles an hour racing? Who does that? Did they act in concert with each other in the course of their activities leading up to the fatal crash? Now, let's talk about that. First of all, this is important because this holds them both responsible, and they're both responsible based on the evidence. So let's talk about it. This is the law, special instruction number 1. You are instructed that a person who participates in, encourages, or assists an unlawful street race may be held legally responsible for harm caused by any participant in that race, even if that person did not personally strike the victim. Remember, I asked Erickson, well, you understand if you're racing, somebody else does it, you're on the hook. Oh, yeah, I guess. Well, of course, counsel, and I'll tell you that when they get up and give the opening statement, say, and he didn't hit him. So what? They're missing the law. We have to prove they engaged, agreed, tacitly or expressly. There's no agreement, signed contract. It's based on the actions to engage in this plan of scheme and racing on a public roadway, and that they knew or reasonably should have known that it was foreseeable risk to others, and they're responsible if it was done in the furtherance of the activity. Clearly, they admitted, and I got the testimony from Peter Grossman and from Erickson, that if you race, people get killed. And then throw alcohol on top of it, and then throw drugs for Grossman on top of it. Each defendant is legally responsible for the acts of the other. It's not a defense that one of the defendant's vehicles did not make physical contact. They kept arguing that, but that's not a defense. They were in it together. They started out together, and let's look at the evidence. Okay. They were drinking together at Julio's before they started. Erickson told Yulson that he saw Grossman a couple cars behind him approaching Lakeview Road. Mutar testified the vehicles were coupled as they were traveling the route. All eyewitnesses and law enforcement testified that they were speeding and racing each other. Everyone except Erickson. Grossman's EDR data shows speeds 73 to 81 in 5 seconds before the crash with a 98% pedal to the metal. That's the evidence. Next. He confessed, Erickson confessed to his 30-year friend Royce Clayton about speeding, racing, seeing Grossman hit the boys and leaving. Both of them, Erickson and Grossman, tried to flee. Erickson fled. Grossman fled a third of a mile till Mercedes shut her down. And as we know, what she told Miss Grosso, she'd be home in bed if the Mercedes didn't shut her down. Next. Deleting messages attempting to secretly communicate via encrypted messaging apps about the crash. How about that? How about Erickson up here? Well, yeah, storage on my phone. What's your phone? Storage, I don't know. Well, you selectively go through and delete messages all about the crash, everything related, conversation, suppression of evidence, admitted, and you'll see that. Threatening this young Miss Grossman. And she threatens Miss Grossman. I love this. Somebody asked this question. Erickson, the whole time, is, I don't know anything. I didn't see anyone. No one was there. I just drove right through it. I had to move a little bit. No one was behind me. But then he's texting her, you lost your best witness when they're coming out against them. Well, if you didn't see anything, why are you the best witness? He didn't delete that message. They were traveling at excessive speed and racing. Remember, a mere preponderance we have to prove. Look at this. Clearly 45 miles an hour marked. So who were the witnesses that said Mr. Erickson and Grossman were not speeding? One person. It wasn't Rebecca Grossman. Scott Erickson. And there's one. What is that? 11 other people testified differently. Now, the number of witnesses doesn't decide the issue. It's the substance of the testimony. Erickson versus those 11. Okay? How about the EDR data and all the other evidence, the videos? So this I wanted, and I was looking at this last night, and something came home to me. So up here is Julio's. Okay? Look at this. From Julio's to Lindero to Lakeview, 1.2 miles. Lindero, Lakeview to Triunfo, Saddle Mountain, 1 mile. Saddle Mountain, Triunfo to the house, 0.8 miles. But the distance from Triunfo and Lindero to the crosswalk, 0.3 miles. Now, a quarter mile is 0.25. Now, look at this. They're coming down here. Prishatel testifies he hears the engines revving. Mortensen's over here by the landing. He's on his bike, feels his vortex, 80 to 100. They're coming down here. Then Prishatel sees them. They will almost run him off the road. He says 70 at this point. Pam Curry, who's walking, sees the racing and the revving of the engines. And you see they have to come here and then turn and go here. So from this distance to here, 1/3 a mile, a racetrack, drag racing, 0.25 miles, quarter mile. Perfect drag strip they made it into. And she just flew. And then, of course, this is where she ends up. And here's Erickson, what he told Royce Clayton about they were effing flying. So there's no doubt. There's no doubt that they were racing. Remember Miss Curry said, oh, she was smiling, hair looking out the window. Sex-craved teenager, she was saying, how she felt with Erickson. No judgment. Terrible choices. But you know why? Because he's a pro baseball player. She's who she is. They've been getting away with this their whole life. He's cold-playing a vehicle for 6 years. I mean, come on, what are we dealing with here? What kind of people engage in this conduct? Despicable, and you're going to hear about it. It's despicable for them to do this. Come on. And they're going to come up here and say they're not responsible and give them some measly amount of money. You see them fight every single thing throughout this trial. They have the right to do it, but now the day of reckoning is here. Now it's here. Now it's time. It's over. I mean, I don't know how many times you see it, probably sick of it, but 98% acceleration up to 2 seconds before impact. I mean, hello? Who does that if you're not racing? Remember, it was only less than 4 miles, 3 miles back to the house. What's the hurry? Debate started at 7. You're already late. Okay? What's the hurry? Why are you doing this? Except for doing this thing, the alcohol impairs judgment. We know that. Undisputed on that too. Mr. Hale, he came, remember, he was the LA County District Attorney and the Orange County District Attorney have an interagency agreement where they can use top people from each agency. So they chose Mr. Hale. And I'll tell you, Mr. Hale, he was impeccable in his work, in his answers, in his opinions, in his qualifications. They never got one thing on him across the other. But listen to what he said.
My first conclusion was that speed is the primary collision factor with regard to this car hitting the boys. And that had the driver chosen to operate the vehicle at the posted speed limit of 45 miles per hour, not the entire time she was on Triumphal Canyon Road, but only for 5 seconds pre-impact, there would have been no crash. She could have driven through with her eyes closed and missed it.
But it said the boys never went home. At 73 miles an hour, that vehicle hit with the same force if you took a crane, attached the vehicle, and dropped it from a 12-story building. Think about that. 4,800 pounds from a 12-story building on these kids. Nobody should have to endure that because someone's out there breaking the law, doing what they want. They can't get away with this. Miss Holm, then she wants to question him. She comes up and questions. Oh, I want to ask about your opinion. If the vehicle was going 45, the accident wouldn't have happened, essentially. He said, not essentially, absolutely. Next, Mr. Morgeson, in the vehicle's past, there was a physical sensation. Yes, that's how I knew they were going so quickly. It was almost I use the word vortex of wind. As they passed by us, that kind of threw us into the driveway. Of course, Mr. Erickson's going 50. Just ask him. Then this Mr. Prechatel. They appear to accelerate what speed? 70, he says. And by the way, witnesses, you get instruction, they all see and remember things differently. You know, this car, that car, they weren't trained to be out there videoing thinking they're going to see someone racing when they're out on a Tuesday night for a walk. They did the best they can. There's inconsistencies, but no one doesn't say they're not racing. No one doesn't say they're not speeding. So, then Royce Clayton, Mr. Braun, he wanted to take on Royce Clayton. Oh, you didn't say this. He goes, let me tell you. Let me clarify. We were fucking flying down the street. Of course they were. Come on. What evidence do they have to dispute that? Tell me any evidence. I didn't see it other than Erickson, and we'll get to him. Miss Nancy Iskander, she saw one black, one white, insane speed coming at her. Imagine her choice. What does she do? She's got 2 children on one side, 1 child on the other. She grabs one to dive out of the way as the car flees and she strikes. She's there perceiving her strike her 2 boys, and then she deals with the aftermath. Were they racing? Let's see. 8 people, yes. 1 person, no, Erickson. So for them to win, you have to believe Mr. Erickson. And if you believe Mr. Erickson, then I need to look for another job. I didn't prove it because the evidence is overwhelming. Okay, then Sheen, they were racing. The lead investigator, Prechatel, what caught your attention? Revving the engines like they're ready to race. Prechatel again, the way they drove their cars, I don't know how I didn't get hit. They were recklessly driving. Morganson, like cars racing, acceleration, high rate of speed, like pedal to the metal, just high rate of speed sound. I don't know how else to describe it. Pretty good, pedal to the metal, 98. And this was incredible. What was your reaction when you saw those vehicles racing by you as you described them? I told my friend that, and I should have said it, but I said, they're going to kill someone. And guess what happened? They're gonna kill someone. Everybody knew. They knew, but they still did it. This is another one. Sands Racing. Aggressive. This is Miss Aktafari Racing. Where's Clayton? You know, they wanted to pick on Mr. Clayton. They didn't get anywhere with Mr. Clayton. Mr. Clayton was, and let's talk about Mr. Clayton. Mr. Clayton, look, this is 30-year friend. He knows what happens. He feels bad. But he's a 30-year friend. He comes from this neighborhood. He didn't want to snitch. He's got mixed feelings. So he calls his uncle or friend, wherever he is, talks to the LA sheriff retired. Guy says, you got to call the cops, man. You got to do that. So he does it. Did he tell him everything? I don't know. Did he tell him everything? He got charged with reckless driving, Mr. Erickson. So could Mr. Clayton maybe told the police more? Maybe he could have. I wasn't him, but I think it was hard enough for him just to go there. But I think he was trying to protect himself like anyone. And he went there. And they tried to pick on him. They got nowhere with him. Nowhere. And then Miss Curry. I had just seen racing cars. And then, you know, less than a minute later, I see all these services passing me towards the cars who were driving fast. Impaired. Not only were they speeding, not only were they racing, they were impaired. Erickson claims he had 3 alcoholic drinks, 12-ounce lager, 2 margaritas, including the big grande, double 2.5-ounce shot. But there's no, it's his word we have to believe he had 1 beer. There's no bill, there's no witness, no nothing. So I don't believe it. And why didn't he stop if there's no problem? Then he goes back and gets his bill. And then we hear from Lexis Grossman, Miss Grossman's daughter, who was at the house. What did she say about Mr. Erickson?
And during your interaction with Scott Erickson in the living room at the post-Frick home, do you recall his demeanor, how he was presenting?
Yeah, as I can remember, he was very angry and frantic. He was kind of like all over the place, as I said earlier. And he smelled like alcohol. I could smell him like alcohol in his breath because he was yelling like at me almost. But yeah, and he looked scared as well.
And then she goes on to say that she believed he was intoxicated. Of course he was. He drinks every day. Now, of course, Mr. Erickson, having a prior DUI and understanding how it works, he flees. No DUI or no blood alcohol. How's he going to get prosecuted, right? How about this? When Mr. Erickson gets his DUI in Las Vegas, he's at such a level that they install in his vehicle a breathalyzer in the ignition where you have to blow into the ignition and show a 0 before you can even start the car. I assume that's where he thinks he got this knowledge where he can determine how many drinks he can have and drive. You heard him, the Erickson scale. Oh, I can have this many, that. I know when I'm impaired. He knows. And he was also told part of his agreement was not to drink and drive anymore. After that DUI, he still did it. Just like here, he came in and lied, said he knew it was lies, and he still did it. He believes he's above the law, as does Miss Grossman. And they are not, and no one is. And you need to make that straight. Okay? Was she impaired? Oh. He says no, everyone else says yes. She says she had a half a margarita, 1 margarita at Julio's, and unknown consumption at the Harris. Officer Kelly doing the DUI investigation, she never admitted she had it. He asked her. She goes, no, denied that. Here he is.
Despite those issues, considering the totality of the circumstances, do you believe that the ultimate results of the field sobriety test that you administered to Rebecca Grossman are accurate and reliable?
Yes.
results from the evidence case?
The totality of talking to Deputy Mejia, my initial contact with her, opening the door, asking her the pre-investigative questionnaires, her performance on the standard field sobriety test. I concluded based on all that she was under the influence of alcohol.
And this is Mr. Kelly. He told this. Remember this? What do you call it? PAS. She wasn't blowing into it. She wasn't really trying to help. But he said, "Is it common or typical that it takes so many attempts?" No. What does that indicate? She's probably trying to hide something from me. I had to put it in manual mode to get the 076, 075 ratings, and we'll get to that. But she was from the beginning. You saw her not blowing into the thing, and of course. She said she barely drank. They said, no way. Her story doesn't add up. And it was determined that she's under the influence of alcohol and causing the collision. And this Takis, he had the same opinion, and here's what he said. Remember him?
What is the basis of that?
It's really based on all the points that you just mentioned. It's the, first of all, using the fact of the crash, 81 mile an hour speed, whatever decision-making process was involved in that was wrong to go that fast. It was the actions after the crash. It was the performance on the standardized field sobriety tests. It was the objective signs of weak odor of alcohol, statements at the scene, and finally the PAS results. That forms a complete picture of the trend.
Undisputed. No evidence disputing that. The blood vials. We had to get. She wouldn't even cooperate. They had to get a warrant on her to forcibly remove the blood from her. 3 hours later. 3 hours later, they had to get a warrant from a judge to take the blood. And then, of course, they go to LA lab. And what do they find? 0.08. 3 hours later. 3 hours later. Why is that important? Well, Mr. Kemp said 0.08, you can't operate a motor vehicle safely. 0.07, can't operate a motor vehicle safely. And you have impairment in your judgment, decision-making, divided attention, like excessive speed, not seeing people, swerving in and out of lanes in a residential area. That's impaired judgment, for sure. And then she goes to the Orange County. Remember, you open the blood. It's going to be less on the next test. We had to bring in every single person. They fought every one of them, every chain of custody of every piece of evidence, every piece of blood, every blood test, every person that tested it, lay the chain of custody. They would ask questions, try to insinuate that it wasn't the blood. You saw all of that. We had to call 9 witnesses just for that. And we proved it, and they didn't do anything, but come on. Okay, and of course, she says, 08, 07, you're impaired. Of course you're impaired. But remember, it was 3 hours later. And of course, she said you would expect it's going to be higher hours before. And she did the analysis, Miss Adiva. If you do this analysis, she would have been a 0.11 to 0.12 at the time of the collision. Well in excess of the legal limit. And how do you get there if you drank half a margarita one? You don't. It's a lie, like everything else. Of course, she didn't come in here and tell us any of that. And she has the right not to do that. But if they don't produce evidence that they have, you can distrust all their evidence. And you'll see that in the jury instructions. Okay, here we go. 0.08, 0.073 takes us to a 0.11 to a 0.12 at the time of the collision. Well in excess of the legal limit. Then we find these benzodiazepines that she has in her system, which, of course, increase the effects of the alcohol. It's an additive. We heard that from Takis and all the other people, the toxicologist. Did they call a toxicologist? I didn't see one. And diazepam. She has that drug in her system. And we're like, come on, where's all this coming from? So what do? We subpoena the Controlled Substance Utilization Review and Evaluation System for the California state. Any of these class of drugs. I know there's somebody who'll know I'm wrong, but I'm not gonna say it. A certain class, and the records show she had the last prescription she had for Valium was in 2016, and she never even picked it up. She had no prescriptions for diazepam. So she's taking these drugs, the evidence shows no prescription. Because it doesn't get in your system if you're not taking it. Taking drugs, no prescription, drinking alcohol, racing, speeding 80 plus miles an hour. Not acceptable in any society.
Objection, Your Honor.
Same.
Improper argument.
So did they act in course together? Absolutely yes. You need to answer this yes, number 5. There's no question. And this is important, real important. Okay, of course she had permission, we already proved that. Now let's talk about the damages now. Because really that's why we're here. I mean, it's not like we weren't going to be able to prove that she was drunk, that she was racing, that she hit the kids, that Erickson was racing her. We're going to be able to prove, but this is why we're here. Because in our society, we place value on things. Let me give you some examples. I was looking this up. LeBron James, $146 million a year.
Objective. My
Messi.
legislative standard, Your Honor, Duarte and Horn.
Argument.
Argument, Your Honor.
Overrule.
If they don't want to hear it, we're not going to talk about how much Mr. Erickson made. That'll be later. But LeBron James, Messi, $400 million. Beyonce, $246 million. Taylor Swift, $500 million.
And objection.
10 million.
Violates Duarte, Horn, and Gregory cases.
This is
Overrule.
not evidence, Your Honor.
Overrule. It's argument.
They don't want to hear this because they know this is a tremendous loss. And they'll say, oh, it's too much money because it's so much. It's so much of a loss. Imagine a mother seeing her 2 kids and perceived killed in the aftermath when she's out for a walk. What worse could happen to someone in our society? And in our society today, we put value.
Your Honor, improper argument.
Precedent admonition, Your Honor.
Overrule.
I'm going to get there. They've been trying to stop me the whole trial, but I'm going to get there.
Objection, Your Honor. That's improper.
Overrule.
Because we're bringing you the truth and they're not. And they don't want the truth because the truth hurts. And the truth hurts Mr. Erickson because he knows he's a liar and a perjurer and committed criminal acts in this case, as did Mrs. Grossman. So those lawyers' job is to defend their client. And that's what they'll do and try to stop me everywhere I can. But my job is to represent my clients the best way I can. And I worry about this part of the case. It's the hardest part for me, for asking for money for losses. And I think about it last night, and I was tough on Erickson, okay? I admit that. I know one speed. I'm going for the truth. And if they're not going to give it to me, I'm going to get it. Okay? And if I was a little rough on him, that's how I am. Okay? Because my job is to take care of this family, to convey to you how enormous these losses are. And that's a hard job for a lawyer. And I've been living with this case for almost 6 years. And when I finish today, it's going to be you. I'm going to turn it over to you. And you're going to be the one that's going to determine what happens. So my job is going to be done. And I've done as best as I can. And I've fought for my clients every day since I've been a lawyer on this case. So how do we value things in our society? Because what you're valuing here is not what someone's death is worth. You're valuing what is the loss of the relationship of the parents, of all the time and the investments that they made, kind of like a stock. You invest in it, you hope it's going to rise, you wait. These people, they didn't invest in stocks, so maybe they had some, but they invested in their children. This was the most important thing to them. Family. Family. There's 3 plaintiffs, you know, you didn't hear from Zachary. We didn't call them. It's too little, whatever. They could have called them if they wanted, but both sides decided not to. So each person decides to get separate consideration. So first we have Mark and Jacob. They both died. They were 11 and 8 years old. You heard a lot about them. And look, I could have gone on for months with photos, with emails, with videotapes, with witnesses, but less is more. You know there's a lot more. We didn't call that many witnesses. We could have called many, many witnesses, but you get the point. I don't think I had to beat it to death. I mean, what this family was like, you have to look at what they had, what they lost, and most importantly, what have they been left with by these defendants. And of course, I told you, Karim and Nancy for past and future wrongful death damages, and for Nancy and Zach, emotional distress, past and future. And I'm going to go to the verdict form, and I'll break it down for you. I'll explain it to you. I spent a lot of time thinking about it. Remember, when they say that's too much money, or you should give $5 million. Remember in the voir dire, they're saying, well, do you think $5 million is offensive? Well, they didn't ask me, because I do think it's offensive. And I think when they get up and say these low numbers, they don't really mean it. They'll have no reason why. They'll just say it to try to give you a low ceiling. All right, so wrongful death. What is the law? The law is that they can recover all of these elements: love, comfort, care, assistance, companionship, affection, society, moral support. And I want to talk to you a little bit about what they are, what they mean, some synonyms about them, and what the evidence was in this case about that. No standard exists. We don't have to prove the exact amount, and it's up to you based on the evidence and your common sense, what is fair to compensate for the tremendous loss. Okay. All right, so here are the elements. You've seen it: love, companionship, comfort. I try to illustrate what they kind of mean, but you get the picture. So, sympathy. There's no sympathy for us. There's no grief or sorrow, mental anguish, the crying for the deaths. Now, Nancy and Jacob, or Nancy and Zachary, they can recover this for the emotional distress part of the claim. But for the wrongful death, this isn't claim. And sympathy goes both ways. Sympathy goes for the defendants, for Mrs. Grossman, for Mr. Erickson. They're not entitled to sympathy. You're not to say, oh my God, that's so much money, what's going to happen to the defendant? Your job is to give a verdict on an amount. You're not to determine who pays, when it's paid, how much is paid, none of that. All you're to do is say, this is what the loss is. And if someone tries to go outside that, you need to write a note to the judge saying they're not following the law. So if anyone brings that up, you got to tell them, no. Our job is to answer the questions and to explain to the other jurors our answers. That's your job. Stick to the questions. All right. What did they lose? Well, here's an example. Look at that family. Who takes all these pictures? Some people. Who sends emails to their children, all of them, so they can remember events and have a catalog? If I didn't see all the evidence, it would be hard to believe that two people that work full time could raise 4 kids like they did, put in the kind of effort that they did, and get the kind of results that they had so far. That takes a special people. Anyone that's a parent knows it's not an easy job. It's not. There's no classes, I guess, but they don't really teach you how to be a parent. Okay, you kind of, it's on the job training. And they were fantastic because it was the most important thing to them. I keep hitting that button. Those two were the foundation of the family. That picture where they're all on the ground and they're stacked up, and you see the 2 boys are on the bottom. They're the foundation of this family. And it was ripped apart. And it'll never be the same. You take these 2 boys, you just wipe them out. And here they are before, and look, they're not there anymore. They're not there anymore because of Mr. Erickson and Ms. Grossman. That's why they're not there anymore. It's not for anything they did. There's no claim they did anything wrong in this case. Nothing whatsoever, except for They made the mistake to go for a walk, not knowing that people are going to be drunk driving racing in that area. And they have to live with that every day. But what happened? Every single day. It never goes out of their mind, ever. So when you're assessing the damages for Mr. Iskander, he has 68 months in the past. That's 9/20, the 9/29, the date of the crash. And you know, they keep saying it's an accident. This was not an accident. It's not an accident when you speed and you drink and you impair drive. That's not an accident. A natural consequence is you're going to kill someone. And that's what happened. It's not an accident. Oh, it's a tragic accident. It's not an accident. It isn't. That's why we're talking about punitive damages, because it's intentional, malicious, despicable conduct. That's why. Looked down by people in common decency. Who would act like that? Who? Except someone that thinks that they can do whatever they want and there's no consequences. That's why we have the jury. Because they can get away with all the way to here, but now it's you. You're the ones that can tell them, no, this is not acceptable. You caused this, you have to pay, and your punitive damages should be assessed against you. And in the future, Karim, based on his life expectancy, and always in the bottom, I put what the jury instruction is. So if you want to mark it down, the judge gives you all the jury instructions, but I'm going to put them down there for you so you know which ones to focus on that I think. But they're all important, so you should look at all of them. All right. Now, Nancy Iskander, same 68 months in the past, and she, I guess the benefit of the woman, she's going to live, well, she's younger, but she's going to live longer, 42 years. That's what the table says. Some people live longer, some people live shorter. The judge read that to you, but you can use that for the assessing the future. So you have 68 months in the past and 42 for her and 32 for Karim. Now, I want to talk about how I went about doing this. It's hard, and I really struggled about it because I don't want you to think that we're just without reason giving numbers. So I try to reason through it as I told you I would, and how did I go about doing it? So I really did it 3 ways. One way is I just looked at it and thought about it. But another way I did was I went through each element, and I invite you to do this. Make a chart of the elements, and then I put the past, and then the future. And I went through each element, and what does that mean? What is the evidence? So what was the fair award in the future and in the past for each element? Then I had to do, because on the verdict form, I'll show you the awards for Nancy and Karim is 1 award. So for the wrongful death of Mark, past 1 award for both, future 1 award for both, and the same for Jacob. Okay, so it's together. So I figured them out differently because she has a longer life expectancy. She's going to be around, according to statistics, maybe 10 more years. And then that would be a time when, as you age, you spend more and more time with your kids. And you really need them. And she's going to be here longer. Karim, according to statistics, won't be here. And she'll be there, and she'll still would have had the support, the love, the care, the guidance with the children. So, love. What does that mean? Profoundly tender, passionate affection for another, a feeling of warm personal attachment or deep affection for a parent, child, spouse, or friend. Synonyms. I think these are good. Tenderness, fondness, warmth, passion, adoration, and devotion. I mean, there's tons of that in this case, tons of evidence. And I'm not going to go through it all. And what I did, I'm going to tell you right now. What I did was I picked out a few for each element. And then at the end, I just put them all together, and I'm just going to play it. You'll see it in the very end. But before I get to that, I want to do highlight some. This is what Nancy said. What made Mark unique? He was all my first. And I was looking forward for him to be my first high school graduation, my first engagement, to attend for a son. And all of the firsts, the prom, 16th birthday, applying to college, going on college tours, going to college, parents come to visit you at college, going to postgrad, you want to be a neurosurgeon, getting married, having children, grandchildren, working, all of these things that are out, gone, never going to happen ever. Get your jury summons. He's not going to happen. Karim talked about him as his dream boy. He was so proud of him. And you could see beaming. When they talked about him, as hard as it was, you could see it in their face, in their body language, how much love they had for these children and how deep, deep that loss is. Here, the firstborn child, this is in Houston, Texas, and you remember the story. Meeting in Houston, Karim going to Baylor, Nancy not getting in, but still getting Karim, and happy endings till now. And Jacob is the boy I always wished I could be my entire life. He was naturally cool, attractive, nonchalant, very, very confident, also very athletic. He makes us proud, and every time I took him to any type of game, he just thrived. And that pride and that love of a parent, seeing a child excel, shows that all that hard work and all the guidance and the training is paying off. And it means something. And you've invested in your children, because that in our society is the most important thing, is our family. Now, in some parts of society, we lose that. We've lost that. But they had really the American dream, because they came here seeking the American dream, and they found it, and they were living it in a beautiful, idealistic town of Westlake. Safe, nice place to live. They had nice jobs, and they get run down by a resident and her boyfriend. Every time it's a different story. This is Karim's brother, Dr. Sharif, cardiologist. Every time it's a different story, through the childhood, what makes them happy. He talks to me as if they still are alive. In his heart, he talks to them as if they're still here, and he loved them much. Remember when Miss Trop asked him, why do you go out there and cross-examine? Because that's the last place my sons were alive, and I talked to them. What kind of question is that? Why would you go out there? Well, we know why Erickson and the lawyers went out there trying to figure out the case, like when the case started. And this sculpture says it all. No heart. I am dead with them. I'm never able to enjoy every moment to the fullest, because part of me is simply dead. My heart is gone. And that's how she feels. And she gets along, and she does the best she can. But part of her is dead and will never come back, ever, ever. And she has to live the rest of her life with that, the next 42 years. Companionship, the art of being with someone, fellowship, togetherness, company, rapport, friendship, fraternity. They had tons of that in this family. They were doing trips. They were doing vacations. They were doing mini vacations. They were going riding bikes. They were jogging. Karim's best friend was his son. I would enjoy him more. He's capable of having really true, deep discussions and total discussions like a friend. What a great relationship. 11 years old. He's already had that. Imagine what it would be in the future. And then when he had his kids and his career and all of that wiped out in 5 seconds because people think they're above the law. Here they are in Egypt, just having a great, look at the smiles. You see the smiles all the time in these pictures. You don't see those now. You don't see that smile. You just see that now. You don't see it. They would run together. They were on the track team. They were running. That's bonding, companionship, comfort, soothe, console, reassure, bring cheer to you, make physically comfortable, support, encourage, state of ease and satisfaction, to pacify, calm, glad, relieve, soothe. Tons of this. Hayalde Hayate. My kids are my life. Mrs. Iskander, she didn't just say that. She lived it. Every single day of her life, she had children. And you've seen the evidence. Nobody. Who does that? The emails. Oh, and I'll show you some of them. Sending emails to all your kids, so they can, 20 years from now, have a record, a digital record of every event in their life. That's somebody that cares, whose family is most important to them in their life. And now their sister comes, the 3 boys, they have a sister. Look at the joy. Karim would said, when I have problems at work or any challenge in life, which like anyone, I had a lot of cushion because I thought, my kids are amazing. I'm so blessed. I have amazing 3 boys and a girl, and Mark is flourishing and setting the stage for his siblings and rewarding for us. I felt invincible. And he did. What a great feeling to be just wiped away in a blink of an eye because people don't care and they think they can break the rules. This is his uncle, Sharif, his brother. Extremely happy family. They sing, they play games, amazing times, love, caring, going to the beach, great memories. But they stopped short by 32 years for one and 42 years for another and almost 6 years in the past. You have to compensate. The law can't bring someone back. The law, look, if we could say open that door and wave a wand and they would come back, everybody would be fine and we'd leave this court and be happy we weren't here. But the law can't do that. But what the law can do is compensate for the loss, fully compensate, because anything less than full compensation is inadequate. So, care. The provision of what is necessary for the health, welfare, maintenance, protection of someone, look after, provide for, needs of, have a liking, fondness, or affection. And I kind of read you those. All right. This is Mark would make surprises for his mom. He'd wake up and get dressed for school. His brother, 6 a.m. Sometimes it was a Saturday. But he was just trying to be a great kid, make things easier for his mom who was working, had these kids. Dad is working, has these kids. But they didn't just abandon the kids for work. They would go, bring them to school together, sometimes one, sometimes the other. They've been at every event, at their school, at the church. They were very actively involved in their children. And then birthdays, cards. He was the heart of our home. He was the only kid who would make sure I got a present from him on Valentine's Day and Mother's Day. And you remember this year, she had no card, and she talked about it when she came to testify. Now, the pastor came, Pastor Chamey, talked about the smiles and the parents and the needs and how proud and beaming the parents were when they saw them. Assistance. And normally you would think the parents would be providing all the assistance to the kid, but not really. Here, there was aid, moral support, emotional backing, moral support, relief, support, help, getting ready, emotionally supporting Karim. Remember, Mark said, hey, Dad, there's some issue going on with the mom. He said, hey, let it go. And he was cluing him in. And he looked to him, and they became close friends. Jacob would organize his room, organize the kitchen, do whatever he could to help his mom. He was very athletic. He would describe himself as a protector, his bodyguard. No one had ever hurt his mom, and he was bodyguard for his little sister, Violet. And Nancy was so proud, no one better to be the best friend through life than a brother. And it's true. Being a best friend with your brother is the greatest thing in the world. And they had each other to balance out their lives, and they had their family, and they had this great family unit that was taken away by pushing down the gas pedal. Affection, tender attachment, devotion, great love, or warmly attached. This is a question of Karim about affection towards the mom. He would compliment her all the time, a lot, he says. The day he passed, when she picked him up, he spontaneously told her, the lunch you made me was awesome. It was perfect balance between health and junk food. He sang to her. He made a surprise for her. You saw the Mother's Day. All. He was very, very affectionate. This is the pastor. Karim was involved in all the sports, studies, school. Family was very affectionate through words and action. The smiles. That's what you're never going to see again, those smiles. And what did Karim enjoy the most about being Mark's father? The joy to his heart, When you're a dad of such a smart and thoughtful and promising and caring kid, you feel secure. You feel confident, protected, proud, and excited. And that's how he felt. I mean, he was on top of the world. He had a nice job, had a great family. They lived in a great place, they thought. They were safe. They were on a huge trajectory upward. And poof, in a matter of time, when people break rules, these things happen. Society, companionship, company, association with others. They'd bike. Remember he talked about they would take their bikes and ride to go get ice cream. That's never happening again. Here they are with the grandmother in Cancun. And they're making funny faces. See them all have the tongues. And that's joy. That's love. That's happiness. That's companionship. That's affection. That's everything right there in that picture. Just one picture. And this is from Dr. Nagel. The home. They didn't change the bedrooms. It was so hard for Nancy to just the reminders, the other kids at the school. Zachary would go to the school, they'd see the other kids that remind him of their kids. And there isn't a day, they said, that doesn't go by that they continually are thinking about it almost 6 years later. And death keeps no calendar. Sometimes in death, you know someone's going to die and you prepare yourself. They have cancer, they have a long-term illness. You're preparing yourself for what you hope doesn't come, but what you know will come, the inevitable death. But when something is dropped on you suddenly, unexpectedly, on an 8 and 11-year-old child, it turns your world upside down. It's not something you ever can recover from. It's not that you sat and prepared. All of a sudden, you go for a walk, and the next thing you know, you're on the ground looking at your two kids dead, one of them thrown 200-something feet, his body mangled because people were not paying attention and drinking and disobeying the law. And then they come here in court and make a mockery of the judicial system. They lie. They hide evidence. And here's Dr. Nagel talking about them having the summer, Mark going to go to Yale, Harvard. He was a smart, he was advanced in math. He was going places. There's no question. Now, of course, he's a 7-year grade. Oh, come on, man. No, this kid was special. These kids were special. This is a special family. And they got to pay. Moral support, emotional, psychological backing, support or help, encouragement or interest. Karim says, I was supposed to be the one teaching the lessons, yet I learned so much from the boys. They were always his teacher. That's what Pastor Chammy said. Here they are with grandma, family unit. How Mark would supply emotional support to Karim. He felt secure. He felt empowered. He felt taken care of. When you don't have to worry, they say that a parent is only as happy as their most unhappiest kid. Everybody was happy here. Sure, I'm sure some days they weren't perfect, nobody's perfect. But if there was some bad stuff, you'd have seen it. Okay? There wasn't. Every day, taken away, gone, poof. Because two people thought they were above the law and they're entitled to do whatever they want. So on the day that when he died, Nancy was crying, telling Jacob, once he knew Mark was dead, said, Jacob, please, I need you. You're my support. I need to count on you. Please make it. Karim knew, talked to his brother, he's probably not going to make it, but he was encouraging his wife. So assessing damages.
Great. Yeah. All right, why don't we take our morning break? Audience, please remain seated until the jury leaves. Do not talk about the case amongst yourselves or with anyone else. Just the podium.
where I left off was we were assessing value. So you have to look at the items, what is lost in the relationship. Is it rare, unique, extraordinary? Does it affect people? This is the Salvatore Mundi painting. Christie's, 435 million. If people could value paintings like that, why should lives
Objection,
and
Your Honor. This is
relationships?
improper argument.
It states the legal standard.
Overall.
I'm gonna get there. Why should people be judged any less? Okay, this again, I told you, you decide the amount based on evidence and common sense. Remember, I told you, if we prove it, are you gonna hesitate? Everything I said, we proved. I'm gonna keep showing you that. Okay, this is just showing, this is for the past, 14,250,000 for Karim, wrongful death. And that gives all the milestones. I'm not gonna go through all that because I gotta speed it up. Future, it's gonna have 10 years, and I broke these up into amounts, 15. I'm gonna give you the amount at the end. So just to show you how I did it. 15 million for 2036 to 2046. And what I've showed is all the different things that are gonna be missing. And then for this time period, 18 million is 2046 to 2058. And the Nancy, the same thing. Same amount in the past, 14,250,000. Future, 15 million for the first 10, 15 million for the next 10, 15 million for the next 10, and then finally 18 million for the last 12. So here's the elements. I told you could write it down if you want, but I'll summarize it. And I listed for the past each element, which I said you should do.
Your Honor, we object. This
And
is
for-
improper.
Overall.
Violates the law in the Roby cases, Your Honor.
Overall.
For 32 years each element, for 5.7 each element, for both. Oh. For Jacob's death, the same. Okay, 28,500,000 in the past for both. I added them both up. 111 million for the future. This is for Mark. This is for Jacob. Or for Mark. Jacob, same. 28,500,000. 111 million in the future. And I asked you, is that a lot of money? Yeah, it's a lot of money, but it's a tremendous loss. It's human lives and relationships and investments. And I want to go to the serious emotional distress. I got to finish by noon, so I'll let you know. Or I could be talking for days and days. Even though they keep objecting, I can keep talking. So.
Objection, Your Honor. That is improper.
Overall.
So, did Nancy Iskander suffer serious emotional stress for being aware of and seeing her two sons killed? Obviously, yes. Dr. Kirkpatrick testified she has PTSD, delayed grieving, which she can have for emotional distress, and depression. No dispute. They didn't even question it. Undisputed. Same thing for Zachary. So, here's what you have to show. That they caused the collision, we've shown that. That her and Zachary were present at the scene, we've shown that. They were aware, of course, they dived out of the way, almost got hit and saw all the aftermath. And she suffered serious emotional stress. There's no dispute on this case that these issues, we met it all. There's no dispute. And they're entitled to recover suffering for anguish, suffering, fright, horror, nervousness, grief, anxiety, worry, shock, humiliation, shame. It exists if an ordinary, reasonable person would be unable to cope with it. In other words, if the reasonable person was walking with their three kids across the street, and they had to dive out of the way of one kid, and two kids got killed in front of them, would they suffer emotional distress? Serious. I mean, come on. Really? I mean, what could be worse? What could be worse for a parent than to see your kids run down by a drunk driver? Okay, Nancy's got past, again, future, the same thing. So when you say past, it's 68 months, future, 42 years. We heard from Dr. Kilpatrick, not even question, no cross-examination whatsoever. Post-traumatic stress disorder, depression, suicide ideation, prolonged grief disorder. Undisputed. She, barely was able to take her, to save one of her sons by diving out of the way. We've heard that. obviously witnessed the aftermath. She didn't have to learn about it because she was right there. So she qualified for the criteria. Let's hear what he said.
She clearly has post-traumatic stress disorder of a serious nature in response to the violent deaths of her two sons. Also reports a couple of symptoms that in terms of thinking about suicide and thinking that she would be better off dead, which is concerning and would be even more concerning, except that I believe she has a strong religious belief, and that her Coptic Christian church takes a very dim view of suicide. The third thing she has is there's something which is a new diagnosis, didn't come into the DSM until 2022, called prolonged grief disorder. I think she has that as well, which is not just regular grief, it's grief that's persisted a long time and doesn't seem to be getting any better.
And there's no question she has post-traumatic stress disorder, and she's never going to be like it was before, forever. Every day is not going to be the same. 50 years from now, 42 years from now, she'll still be thinking about it. And she said, I'm a broken mother. Part of me died with them. That person completely is gone. It's now a different one that's broken and grieving and thinking about the loss all the time, thinking about what if they were here. So here's the numbers for Nancy. And it says you must award money for every item that we proved. And we proved every one of those items. We proved them all. There's no dispute. They didn't offer any evidence whatsoever to rebut any of this. And we'll get to the final. Obviously, you got to check the box that caused the injury. And this is what I believe, 25 million in the past, 75 million in the future. I told you it's going to be a lot of money. I told you hundreds and hundreds. But we proved it. We came in here and we brought the evidence. And everyone told me, everyone, they wouldn't hesitate if we proved it. We proved it. Zachary, same. I mean, look at those smiles. Never, ever will those smiles be seen again for the rest of Nancy, Karim, and Zachary's life. Ever. Ever. They should have thought of that before they took the road. Now he has 67 years in the future to think and remember and see his brothers getting killed. Time does not heal that wound. Time continues to drag, and he continues to see that. He's having flashbacks, nightmares. Of course, what would you expect? What would you expect to be someone's reaction? Why should a 5-year-old have to see that? Why did Mr. Erickson have to do what he did and Ms. Grossman to cause Zachary to go through this? Why did they do that? Because they're self-entitled, think they can do whatever they want, not obey a law. Numerous evidence of that. All right. He has loneliness, confusion, difficulty making friends. He lost his 2 best friends. And so this is Sharif. He was only 5. He witnessed the accident. He had a lot of questions. He saw with his own eyes. It was the biggest trauma a 5-year-old can have. Can you think of a worse trauma? I can't think of something that could be worse. And here's the pastor talking. Did you notice a difference in Zachary's demeanor, personality, and effect after being present when his brothers died?
Yes.
Please tell us about that.
There was a sadness, a heaviness, and
there were days when he would be excited about something, like when the talent show came up, and you remember how his brothers performed in the talent show. And then he'd go to a sadness because then his brother wasn't there anymore. And he would do that with Mark and Jacob, and school was harder for him. And then days where the Iskander children are these very loving, affectionate children, and they are children who have always gotten along. And some days just playing was overwhelming. And so I would just hang out with them.
This is Karim talking about how it changed his life. Kept trying to find himself, referring to Zachary. Completely heartbroken, doesn't laugh, doesn't smile like he did before. Broken heart through a smile even more than when he's not smiling. And this is the mom. He was really sad, upset, crying. A lot of confusion, fear. All of a sudden they're gone. And then remember, several days after the death, Nancy Iskander had to go tell her youngest son what happened to his two best friends and his brothers. And his reaction, and her having to do that, and the feeling, and the tremendous. He's struggling with nightmares. That's what happens in post-traumatic stress disorder. Like vets, you have these intrusive thoughts, these nightmares. You're waking up at night. He's not making a lot of friends. He feels in a situation where no one really understands him. They just don't understand. Who else has lost two brothers that they saw, that he goes to school with? Okay, here's the numbers. I did the same thing, past and future. And then right here, 20 million past, 40 million future for Zachary. You could give more, you could give less. It's up to you. And I invite counsel to come up and reason with you what's fair and reasonable for these things. Because I'm going to get to come back and respond to them when they're done. Okay, so I told you we're proving. Let's see what they told you they were going to prove in this case. Because you remember in the beginning, that would have been April 27th, gave the opening statement. Okay, I talked, Ms. Holm talked, Ms. Trop got up here, and they told you what they're going to prove in this case. And I told you one thing. What did I tell you? I know you remember. Hold me to everything I told you, everything. When I said it in the beginning, 6 weeks ago, whatever that was. But let's see what they told you they're going to prove. Red herring. Red herring is a herring that you drag around and distract when you're trying to get somebody off the scent of the trail, okay, when you're hunting. And this is what they have. Whatever they say, we have a right to cross-examine. And the single greatest engine for the discovery of truth is cross-examination. Anyone can come up here and say whatever they want, but the other side gets to cross-examine them and test that truth. And remember, we're here in a search for the truth. So let's look at the Mr. Number one, I'm not impaired. How about that one? Stood right over here, and this is what she said. We believe the evidence to show Ms. Grossman was not driving impaired. She had a margarita, but believe the evidence shows she's not impaired. Really? Really? Here's a list of them. Kelly, Sheen, Mejia, Takis, Kim, Vanessa, Avida, Budar. They all said impaired, caused a collision. Next one. But where's Ms. Grossman to say that? Or where's anyone to say that? It's undisputed. She was impaired. No question.
Sustained.
Where's the evidence being offered by Ms. Grossman that her lawyer said that she's not impaired? Where was that evidence? Where was it? Ms. Hom will come up here and tell you where that evidence is, that what she told you she's going to prove. Remember I said hold me to it, hold them. Next, not speeding. We believe, this is what she said from the transcript. We believe the evidence will show Grossman was traveling much slower at impact than Mr. Erickson and much slower than EDR. Where is the evidence? Where is it? I'm sure she'll get up here and tell you how that was not a false statement, okay? Where is the evidence? There is none, but they tell you that. What else did she, and here it is, here's the evidence. "73 miles an hour, 98% all the way." Hello? but she wasn't speeding. That's what they're gonna try to tell you. That's what lawyer would stand up here in the face of all this evidence and tell you that?
Objection.
You gotta ask yourself,
Sustain.
why would Mrs. Grossman's lawyers take this position that she wasn't speeding when the evidence is overwhelming? Because you're just hoping you're not gonna follow the evidence. Give her some sympathy. Okay, next. Speeding, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 witnesses speeding. 11. What evidence did the Grossmans put on she wasn't speeding?
Objection, Your Honor.
Zero.
Improper.
Overruled.
I'm gonna still get to say what I'm gonna say. Next one, not racing. What did she tell you in the opening statement? I cannot speak for Mr. Erickson, but I believe the evidence will show that there's no evidence that Mrs. Grossman was speeding. Racing. I meant to say racing. No evidence she was racing. Really? How about 1, 2, 3, 4, 5, 6, 7, 8, 9 witnesses? How about them? How about those 9 witnesses? She get up here and tell you there's no evidence? Hello? Next. Oh, but Erickson's at fault too. Okay? Well, I'm not at fault because she's never ever admitted any responsibility from September 29th until June 1st, 2026. They've never accepted any responsibility, nor has Mr. Erickson, and they won't. It's up to you to hold them accountable. Oh, here's another one. There were issues regard to Erickson's conduct, and you will be the sole interpreters of whether that conduct was wrongful. We'll tell you that he saw the children as his car entered. He didn't stop. He didn't flash his lights for Rebecca to see. He didn't do anything to warn her because he was behind him and he wouldn't have been able to see. Interesting, did you see when Mr. Erickson was up that Ms. Hom was asking me softball questions trying to help her case? And you see how they say they weren't racing, but they're together, the lawyers, the witnesses, all of them. It's still going on today. She never saw the children. No evidence of that, just the lawyer saying that. No witness came in and said that. The evidence would show Grossman never saw the children in the crosswalk. Her view directly in front of Erickson would have been blocked. She didn't see the children and then her airbags deployed. She didn't know what happened. Really? Did she prove any of that? First of all, the airbags deployed after you hit someone. Okay? They put that little tape that says after they call her and they hear the sirens going and they say, stay where you are. Well, she already fled as far as she could because the car ran out. So what did Mr. Muttard say, Dr. Muttard?
Can we agree that Mr.
This is
Erickson's
Ms. Hom
vehicle
questioner.
would have been blocking the view of Ms. Grossman's vehicle at the point of the impact?
If she's following too closely, it would have been some obstruction. However, the curvature of the road in that area, for example, when you're like 5 seconds before impact and you're in the left lane, you have a direct shot, a direct view of pedestrians coming off the beat. So the car in front of you is now off to your left because of the slight curvature of the road, right? So unless you're literally on the tailpipe of the car in front of you, and that would be part of the erratic behavior. But if you're following at any reasonable speed, that lead vehicle shouldn't be much of an obstruction.
They have no contrary evidence to that. How about this, Trooper McGee?
When you were at the hospital and you were with Rebecca Grossman, did she ever say anything to you or say anything that you heard or overheard?
Yes, sir. We were waiting to have the blood drawn, and the news came on. In the short time that the news came on before I got there, so I unplugged the TV. Ms. Grossman saw the news, realized it was the incident she was involved in, and made statements about seeing the kids in the street.
What? This is what Rebecca Grossman, while the hospital said. Why were the kids on the bike in the dark? Why were the kids in the street in the dark? First of all, it was the dark. Second of all, there's no bikes. She's impaired. Then she texts her friend, Rose Wilshire, and the text says, I do take accountability that I turned my head to the right, probably 1 or 2 seconds longer than I should have, when I saw a woman crashing on rollerblades on the right side of the road. I did not know it that night, but it was the mom. Did I read that correctly? Answer, yes. And this is information Rebecca Grossman specifically texted you. Answer, correct. I mean, come on. She saw it. Of course she did. But she didn't care. Remember, she was smiling at Miss Curry as she went whizzing by. Oh, this is a good one. Well, she didn't try to flee the scene. That's what Ms. Hom told you in her opening statement. Her car disabled. Her car stopped putting fuel in, and it kept coasting. That's why the car is down the road. 911 operator discussed with Ms. Grossman, gave instructions what to do, stay where you are, stay with your car. And that's what she did. She already fled a third of a mile and her car gave out. She didn't do it. She fled. There's no question. And Mr. Mejia, Detective Mejia, did Ms. Grossman explain why her car stopped, I believe, 1,500 to 1,700 feet down the road? Answer, she said it stopped. It was stopped because Mercedes had disabled the vehicle. That's what she said right away to the investigating officer. And what about Mr. Gadet, Officer Gadet?
I want to go back to your response to the scene of the crash. You purposely chose to go a route that you believed was different than the route some of your fellow deputies was taking.
That's correct.
And you did that with the intention of potentially seeing an involved vehicle that had fled the scene, right?
Correct. Any vehicles that could have potentially had damage or appeared to be involved in traffic collision.
And you saw that.
I did.
Describe that vehicle.
It was a white Mercedes SUV with extensive front end damage.
And did you at some point later learn who was driving that vehicle?
Yes, I did.
Who?
Rebecca Grossman.
You saw Miss Gadet. It was very emotional for him, for what he saw at the scene. And he told you about how Mr. Clayton was very guarded when he interviewed him, and how he thought Mr. Clayton was probably covered for his bite, Mr. Erickson. But they called him as a witness. That was the only witness that Mr. Erickson called in this trial. That was it. I love this one. She didn't flee, right? So Ms. Hom gets up here and asks the detective this. Listen to this.
If the car was towed and not started, there should not have been an additional 15 ignition cycles. Is that correct?
That's not correct. There's explanations for that.
Then she asked him.
Okay, let's hear it.
Well,
Let's hear it.
in a case where there's a hit and run, a driver's trying to start the car and get away after, but is unable to because it's been disabled, each time that driver tries to start that car, that'll induce an ignition cycle.
She asked that question. She's trying to continue to flee. This case, this is frivolous right here. When people fail to accept responsibility and start blaming others, when you point the finger, there's 4 fingers pointing back at you. So what was Mrs. Grossman's case in this defense? Was it she wasn't speeding? No. Was it she wasn't drunk? No. Was it she didn't kill the kids? No. It was the city of Westlake's responsible. How about that? The city of Westlake is responsible because they maintained a dangerous condition, really. They called 7 witnesses on that. What did they prove? They proved nothing. This is what they proved. They proved, and you just got to answer this question, did they own the intersection? They did own it. She proved that. But right here, number 20, was it in a dangerous condition is no, and you should go, that would be the end of that. You don't have to answer any other questions. They didn't know about it. Dangerous condition is a substantial risk of harm used with reasonable care in a reasonably foreseeable manner. And reasonable care is not going 73 to 82 miles an hour. And reasonable care is not drunk driving and speeding and racing, okay? But on top of that, how can they come in with a straight face and make this claim? I don't get it. They have no evidence. None. And I'm gonna show you that. No evidence. This case shouldn't even be here. This is what she told you she's gonna prove. The city of Westlake was aware of these issues that I'm talking about, the lack of stoplights, they didn't even talk about that. Stop signs, they didn't talk about that. Flashing lights, they didn't talk about that. All of that they were aware of. So the evidence will show that the city of Westlake knew of the problems and didn't do anything about it. Well, that's a pretty bold statement. So where's the evidence? You know, lawyers can get up. Remember I told you, lawyers can say whatever they want, but you got to hold them to prove it. They didn't prove anything. In fact, they proved how safe the roadway really is. Because let's look at the evidence. First of all, they called in Mr. Wessel, the former traffic engineer, 33 years Westlake. And what does he say? The design and layout of the marked crosswalk at the intersection complied with all applicable engineering standards. The crosswalk was designed in a reasonable and safe manner. The crosswalk was not dangerous anywhere. That is the evidence, okay? But they don't stop there. Installing enhancements that people complain and say should be, that doesn't necessarily mean that you should do it, does it? That's correct. Why not? You can make it less safe. They deliberated, they had meetings, they addressed it, and they didn't make a change. And listen to what he said. And can you tell us how you can prevent a drunk driver from running over someone in a crosswalk with the design of a crosswalk?
There's no way.
How can you prevent people that are going 73 to 80 miles an hour in a 45 mile an hour zone? How can you design that out?
Cannot for impaired driver.
How about for a speeding driver? At least 35 miles an hour plus over the posted speed limit. How do you do that as a traffic engineer?
Can't do it.
You can't. This is ridiculous. I mean, who would stand up and say that? It's insulting. It's insulting to me and to anyone who knows what's going on in the road. That's a joke. I mean, come on, accept some responsibility. Don't keep blaming everybody else. How about this? Mr. Dunlap. The design met all design standards, operational standards, any enhancements that are going to be projected to increase safety in a safe operating intersection. And what did he say, Mr. Dunlap? What is your conclusion about whether the intersection presented a dangerous condition of public property that contributed to the death of Mark and Jacob Iskander?
It did not contribute to the
Why not?
accident. The outcome, causation of this accident, in my opinion, was a careless driver that was intoxicated and traveling at twice the posted speed limit.
That's what happened. When you're designing the road, are you designing it for people that are going to use the roadway when they're under the influence of alcohol, traveling at excessive speeds?
No. We don't.
Why don't you do that? Why don't you make the road, no matter what, there'll never be an accident? Why can't you do that?
Well, yeah. If you try to do that for drunk drivers or intoxicated drivers or on drugs, drivers that are going to drive at whatever speed they want to, you would never be able to build anything safe. Even a freeway is not going to be safe for a drunk driver. You have levels of intoxication and unpredictable reactions from drivers and what they're going to be able to do. It might change from person to person pretty extravagantly. So that is never designed into a highway. When we do highway design, we establish it for what we would consider a due diligence driver.
So what evidence did they put forth? Oh, they called that Kwasniak. Remember that guy? I didn't even finish crossing. I mean, you got to be kidding me, right? That's their case. Here's Ms. Hom question.
A letter about a person who was trying to cross the street and they had to run across because the car was about to hit them?
I do remember letters like that, yes. I remember a letter that specifically stated that. That doesn't necessarily mean that the driver didn't have the opportunity to be able to observe them. You're talking driver negligence versus the city's negligence, and the city's negligence is non-existent here. We are operating this intersection pursuant to the engineering standards for a safe operating intersection, and the accident history bears witness to that. Therefore, if you have a negligent driver that's not stopping for somebody, that doesn't mean that they didn't have opportunity to see them in the crosswalk and stop. It just meant that they didn't.
And is Mr. Sands.
In all the years around that intersection, do you ever have issues crosswalk that southbound and northbound?
No.
Did you ever see pedestrians crossing within that crosswalk?
Yes.
Did you ever feel that your line of sight was blocked by anything as you were approaching it?
No, sir.
Did you ever have any issues or challenges navigating or driving a vehicle up Triumphal approaching southbound drive?
No.
Did you feel that the intersection was dangerous in any way?
Not at all.
Now, we get to Mr. Kwasniak. I gotta tell you. Mr. Kwasniak testified that he read the deposition of Rebecca Grossman and billed them all about the speeds and everything that she was doing. The problem with that is there's no such deposition. That's who they brought in here. Let's talk, let's see what his real opinions were when I finally got him to answer the question.
Let's talk about
He's got that little smirk.
These 250 parked cars, feet of parked cars, you're saying the city should have removed it, but you're not saying the accident wouldn't happen, are you? If the cars were removed.
I'm saying that the side distance will increase dramatically.
Are you saying that if you take out all these cars, the accident is not gonna happen?
I don't know one way or another because I don't know what the speed was.
Therefore, you could not give an opinion in this case that removing the cars would have changed the outcome, can you?
I'm not actually a constructionist, I cannot.
So they have no opinion of that, no evidence of that, no reconstruction. So let's go further what he said.
Well, you don't have an opinion, and you haven't expressed the opinion that this public property was in a dangerous condition and that the city had notice, do you? You didn't give that opinion, did you, sir?
Not as of today.
Not as of today. What's he waiting for? Next week, maybe he'll come to another case and get an opinion. He has no opinion. What? There's no evidence. This shouldn't even take 2 seconds. There's no evidence. I can't believe this is even being decided because there's no evidence. None. Zero. Their own expert can't say it's dangerous. Can't say it would have made a difference. Because people deny responsibility, and just like an octopus, they put out ink to try to obfuscate everything else. The truth is, they were racing. He almost killed them. She killed them. They both fled the scene, and they were impaired. That's the truth. That's what we proved. This one, I love this one. 21 million to 24 million, 0.6 cars went through that intersection in 10 years, 1.8 million pedestrians, no accidents, pedestrians and cars. The only one ever was this one. And then they called those city managers, who they got nothing out of. And I said to the one city manager, the one that was there for 33 years, also, maybe a little less. In the history of that roadway, has there ever been a pedestrian auto accident? No, never. Never, except for one time when Mr. Erickson and Miss Grossman were racing impaired down that roadway, hustling over to her house, for her and her husband's house. That's a whole other issue. The fact that some lawyer is going to stand up here and tell you with no evidence that that is dangerous, that proves that they deny all responsibility and refuse to accept any responsibility, and you're the ones that can impose liability, responsibility, and accountability on them. Only you can. Only you. So they own the roadway. We'll give them that. You answer number 20, no, and you stop, and that's the end of the case. That's the end of the questions you have to answer. I'm not even going to go through this foreseeable risk of injury. Is it foreseeable if someone's going to drunk drive and race and run someone down? No. And this one, I really love this one. Look at this. So we think there are other factors involved. She still hasn't admitted anything. That there was a rush to judgment to immediately determine that the entire accident was caused by the fault of Rebecca Grossman. Rush to judgment. So let's blame the city. Now we're going to blame the police department. So the police department had some axe to grind with Rebecca Grossman. They find these 2 dead boys in her car with 2 dents on it, and they rush to judgment to blame her. Okay? That's one of their defenses. So what evidence did they put on? Did they call a single police officer and ask him that? Did they question any police officer that came about that? Lawyers can say whatever they want, but they got to back it up with evidence. And when they say things they don't back up, there's a reason why they say them. And I know you know what that is. So, rush to judgment. Wow, where have I heard that before? Then I asked Mr. Takas, did you see any evidence whatsoever the Los Angeles County Sheriff was engaged in a rush to judgment? No, not to my knowledge. Sheehan, same question. The investigative 30-year police officer. He's going to rush to judgment against Rebecca Grossman, please. Okay? Come on. People don't like it when they get held accountable. They always deny, oh, I'm innocent. I didn't do it. Let's see what Mr. Erickson's contender. It's all Rebecca's fault. It's all Rebecca's fault. I didn't hit him. Remember that one? That was nobody said. That's great. So here we go. Here's again Ms. Tropp's opening statement. You will also find out that all the investigations done by whether it was the police or the sheriff concluded the same thing. This was an accident. Nobody concluded it was an accident caused by Grossman, and it was her vehicle that struck the children. Well, partially that's true. She did strike the children, but she missed out the most important part. Scott Erickson and her are both liable, joint and several, on a concerted action racing for what they did. You can't let one person off and then get both the people are responsible. You need both for it to happen through the whole event. And of course, Erickson admitted he didn't yield to the boys. He admitted that. He blocked his escape route of the kids was blocked. Remember, so as they're coming and Rebecca goes through, I mean, they're just right there stuck. Erickson goes through like sitting ducks. She picks them both off. They had no chance. No chance. That's how their life ended, looking at Rebecca Grossman coming 70, 83 miles an hour, like being dropped from a 12-story building. That's how their life ended. And this is a great defense. Well, he never made physical contact with the boys, therefore he's not responsible. Really? This is the jury instruction. It is not a defense that one defendant's vehicle did not make physical contact with the victims. But they're advancing that defense. But that isn't a defense. That's the point. The law, you have to follow the law. Lawyers can just say whatever they want, but the law doesn't allow that. Physical contact is not required. Plus, he's liable for cutting off the path for escape and under the concerted action theory. So, why would a lawyer misstate the law? Oh, there's another one. He's not impaired. Well, first of all, the evidence will show, this is Mr. Erickson's lawyer, Ms. Trop. Evidence will show that statements Grossman made, such as he was drunk and screaming at her, first were out in this case 2 years after the incident, and the evidence show Alexis Grossman changed her story at least 2 times. Where was that evidence? There's no evidence of that in this case. You can absolutely see her video deposition. There's absolutely no evidence that she had any other story. There's no evidence that she changed her story. The lawyer just said that. I want to see when they come up here, wait and see when they're going to show you that was in evidence. There is none. They just keep saying things that aren't in evidence. Remember I told you, hold them to what they say they're going to prove. Hold me to what I said I'm going to prove. I'll give them a pass. So here's the response. He claims 3 drinks. We know. Undisputed from Alexis, he was intoxicated, racing at a high speed in a heavily pedestrian traffic area. Who would do that? Impairment, judgment. Undisputed fled. Undisputed 72 to 78, 250 feet after the collision. Hide in the bushes. Admitted lying repeatedly to the police. Admitted switching vehicles at Coldplay. I mean, who does that? That's a criminal act. That's a criminal act. And he's continuing to do it to this day. And you're going to hear no evidence or no argument that it's not true because he did it. And he continues to do it. And he doesn't care. He doesn't care about the law, and you're gonna see that. And of course, how can they find out if Erickson's drunk? Well, when he leaves the scene, because he knows he's already been caught once for DUI, he knows they get the blood alcohol, you're cooked. So if you're not there for the blood alcohol, when he's calling the lawyers from the scene and they're telling him to go back to bed and stay away, that's circumstantial evidence that he's drunk. Not speeding. Remember that one? I was going 50. He says he's going 50 to 50 miles an hour, 20 to 30 feet before, sees the two kids at the crosswalk. That's what they told you in the opening statement. Now, 11 people give contrary evidence, plus the surveillance, and those 11 people all said they were speeding, 72 to 78, 250 feet past, racing ahead of this Grossman. That's the evidence. Then, Mr. Castaneda said, is there any evidence whatsoever he's 50 to 55? Given the totality of the analysis, no evidence to support a speed of Erickson anywhere to 50 to 55. Where was their expert to say that? What evidence did they put on that that was the truth? They put on one piece of evidence, you know what it was? Mr. Erickson. Mr. Erickson, who's not worthy of belief, I submit to you, ladies and gentlemen. Not racing. Erickson's going to testify. He was not racing. Imagine that. You know, what do they say? Oh, what a web we weave when we seek to deceive. You know, you can't have a good enough memory to be a liar. Okay? Nobody has a good enough memory to pull it off. Pitch Black, love that one. And you're going to hear, this is again Miss Trop telling you what she's going to prove, that it was dark at 7 p.m., a little past 7, and every other vehicle on the road had their headlights on. Okay. Was it dark? It wasn't pitch black. Erickson, this is what he says, the Iskander boys would have been visible to drivers paying reasonable attention to the road, obviously. But lighting, Denton, it was still light out, the paramedic. Clayton, he was going to go surfing. Miss Iskander, still light. Pamela Curry, it wasn't dusk yet. Corey Gaudette, it was dusk when he got there. But guess who's the only person in the case that says something different? Miss Erickson. No evidence from Miss Grossman on that issue. And then Jake Sands, everything was well lit. Well lit. Sheen, when they were struck, well lit. Mutar, far exceeded the minimum standards, only got better as you got closer to the pedestrians. Come on. Lighting, road, that's nothing to do with it. It's the driver. It's the drivers, of course. You saw the children made a split decision to not hit him. I love this one. This is what counsel told you. He's thrilled, grateful, breathing that he got through the intersection in that crossing. Breathing, what is that? Is he doing some kind of transcendental meditation or yoga or something? He's grateful. Has he ever told you that? He's grateful. Did you see any evidence he's grateful he didn't hit him? He like booked to her house. That's what he did. Grateful? Well, we're not grateful. We're not grateful for what happened, but he's grateful for what happened because he's in the race. Doesn't matter if he hits him. He's responsible, but he's grateful. Grateful. And he's breathing. Did you hear him say that about his breathing? There's no testimony on that. What is that? What is that? So Mr. Mutar said about that.
Based on the evidence and the opinions you formed in this case, was Mr. Erickson's speed consistent with Rebecca Grossman's speed in the approximate 5 seconds before the impact?
Yes.
Was there anything blocking Scott Erickson's view of the marked crosswalk that Mark and Jacob Iskander as they approached?
By all accounts, he is the first in line in the middle one lane, in the left lane. He's in front of the Grossman vehicle. There's no vehicle in front of him. Once he, gets past the Iskander, past the Karim vehicle that was in the right lane.
At a speed of 45 miles per hour, would Mr. Erickson have had adequate information to
yield to Mark and Jacob before reaching the crosswalk in an unimpaired condition?
Yes, so based on the information we have in that regard, he saw the children up ahead. He said he saw the children up ahead, he saw the shiny thing. He was recorded as saying that he swerved to avoid the boys that were up ahead. So that would suggest to me if he has time to swerve at 80s or 70s to 80s miles an hour, then he certainly had time for an avoidance response at 45. And so, yes, that would have allowed him to avoid or yield.
Did Mr. Erickson yield to Mark and Jacob Iskander in the crosswalk?
No, he did not.
That evidence is uncontroverted. Nobody came to say anything different. No one, because it's the truth. It's the truth. Mr. Erickson, I didn't flee. No, I didn't flee. Erickson doesn't know anything that happened behind him. He's not fleeing. He'll tell you he's not fleeing. I'm going to tell you right now, anything that Mr. Erickson tells anyone, in my opinion, is suspect. He's an admitted, repeated, pathological liar, perjurer, suppressor of evidence. He's not worthy of belief about anything. What else did Erickson tell you that night? That he swerved and kept going, went to her house, Grossman's house, decided to jog back. That's what he told his buddy Royce Clayton. Now they're going to come in here and say, oh, Royce Clayton made it up. What was Royce Clayton's motive to make up what Erickson told him of his 30-year friend and have to expose himself, go to the police? Was this his motive to get Erickson in trouble? Was he going to go lie to the police so Erickson would get in trouble? He wasn't even there, even though he was with them when they had a drink. At least one. Two, actually. And he told Clayton that he looked at his rearview mirror and saw him hit both the boys. Is Clayton going to make that up? Come on. And then this Mr. Sands was there for 2 hours, approximately. He never saw either one of the Mercedes return. So now I want to talk to you about punitive damage. This will be the last part. So what's going to happen is you're going to answer these questions that I've gone through so far. And then you're going to get to these next two questions. And I believe you should answer them yes, and I'm going to explain why. And then there's going to be a brief second phase of the trial. And in that phase, we're going to get to introduce all of the evidence about the financial condition of the defendants. In this case, you can't decide this based on Judge gave you the instruction, wealth or poverty of the parties. Whether it's Bill Gates or a pauper, they're entitled to the same consideration, okay? Whether they're the defendant, if it's the richest person in the world or the poorest person in the world, that's not to be figured into your decision. Your decision can only be based on the evidence. You can't discriminate. You can't give more money because they're rich people. You can't give less money because they're poor people. But then, in the punitive damage phase, all of that is relevant. And if you answer those two questions, which I believe you should, then we'll come back briefly and we'll get to put on the evidence of their finances and how much money they have and all that stuff. But we can't do that in this case. And you can't give money whether you think someone's rich or poor. It can only be based on the evidence. But in the second part, it's different. And it's also different because in this part, you can't award money to punish. You give money to compensate. But in the next part, you get to award money to punish and to stop them and deter this kind of conduct. Okay? But you're not to do it here. You're just to answer these two questions. We'll come back. We'll be brief. We'll be out of here on a deadline. We need to be out of here. But let's talk about it. What do we have to prove? Number one, you must decide based on the evidence by clear and convincing evidence, which is a higher standard than this. It's not beyond a reasonable doubt. It's like 75%. I'll show you. You must decide whether plaintiffs proved by clear and convincing evidence Rebecca Grossman and or Scott Erickson acted in conduct, malice, fraud, or oppression. The amount of punitive damage would be decided later. I told you that. All you're answering is yes or no right now. Now, malice means conduct of defendants that was so despicable and was done with a willful and knowing disregard of the rights and safety of another. A person who acts with disregard when the person is aware of the probable consequences of the person's conduct and deliberately fails to avoid the consequences. This case. Intentionally knew they raced high speeds, they know the probable consequences, because I asked them, and I'm going to show you. Oppression is despicable and subjected plaintiffs to cruel and unjust hardship and knowing disregard of their rights. Erickson admitted this, and I'll show you. But don't you believe, based on the evidence, that someone that's going to go drink alcohol on a Tuesday night is going to speed home, going to run over 2 kids and leave the scene? That is despicable. I don't think of anything that any chance it isn't. But not only is it oppression, it's despicable conduct, it's vile, base, contemptible, that it would be looked down and despised by a reasonable person. Does a reasonable person accept people speeding, driving alcohol with alcohol, drugs, killing 2 kids, leaving, denying everything? Is that what a reasonable person would think is vile, base, contemptible? Absolutely. Absolutely. Meets the definition of all of them. Fraud. This is only applies to Erickson. Intentionally misrepresenting. He had facts upon facts upon facts, intending to harm the plaintiffs. Exactly what he did. And let's talk about it. Oh, and here's the clear and convincing, highly probable that it's true. There's no question it's true, beyond a reasonable doubt. So preponderance, it's like the 50.1. Here's clear and convincing, so approximately 75, and beyond a reasonable doubt, 100%. So we're everything is preponderance. They're more likely true than not until only punitives. Those 2 questions have the clear and convincing standard. I think we met it, no question. So let's look at the evidence. What were they doing? They were racing each other in a heavily trafficked location used by pedestrians during COVID, when people are out with racing at speeds in excess of 80, while impaired, tried to flee the scene, and full knowledge that this type of conduct can result in serious harm to others. No one in the world would tell you that racing and drinking through a pedestrian area, a probable consequence is not to hit someone. Nobody believes that. No one in this world, except maybe the defendants. Let's hear them say that that's not a probable consequence. Okay, so let's look at Rebecca's conduct. Okay, there's the crosswalk, and way up here is where she stopped. But she did knock Jacob over here and Mark way down there. Yet she says she didn't know she hit anyone. Well, we don't know what she said because we don't have that testimony here. They didn't offer any evidence of that. She didn't offer any evidence in this case.
Objection, Your Honor, improper.
Overall. She didn't offer any evidence except for the dangerous condition, 7 witnesses. That's a tie. All right, now, had she applied the brakes, it would have only taken her 456 feet to bring her vehicle to stop. Instead, she tried to flee the scene, and the only reason the vehicle stopped was because the Mercedes automatically shut down the engine after impact. Additional instant cycles occurred, as you saw Mr. Hale said, when Miss Palm asked him, well, how do you explain this? He goes, well, there's an explanation. Well, tell me. Sure, I'll tell you. She's trying to flee. She keeps starting the engine. Hello? Next. This is the tech at the hospital. What did she say? She told me that she would be home in her garage if they didn't disable her vehicle, Mercedes. That's malice. That's oppression. That's not acceptable by regular people, reasonable people in our society, that kind of conduct. She was intending to flee. She tried to flee. And she, unfortunately, Mercedes had a device that prevented it for her. We know the blood alcohol, 08, the 3 hours later, 7.3, 7.4. Remember, they opened the vial. It's going to be a little less. 1.1 to 1.2. That's the evidence, undisputed. Not a single piece of evidence disputing that. Everything's undisputed. They didn't attack any of this. They have no evidence contrary. And Mukhtar, what did he say?
Ms. Grossman was traveling 45 an hour and needed only 204 feet to stop. What would have happened?
There's no crash. She doesn't get there. She didn't have to brake, right? But they're not there to be hit. And certainly if she stops, if she does brake at a normal rate, she never gets to the crosswalk.
let's talk about Mr. Erickson's punitive damage conduct. I believe you have to answer both these questions yes. Otherwise, it's a victory for the defendant. And there should be no victory for the defendant here based on the evidence. None. They're guilty. They're responsible. I should say they're responsible. They're liable. They won't admit it. Only you can assess it. Okay. These, somebody should write these down because these are important. I didn't want to put them all out. But these are when you're looking at Erickson's punitive conduct. So it's Casey, that's the name, and you'll see there in your packet, number 362, which is consciousness of guilt, liability, false statements. 371A, consciousness of suppression of evidence. 371B, consciousness of liability, fabrication of evidence. 371B, suppression of fabrication. 372, flight, and special instruction 2. And those talk about what the legal significance is of somebody destroying evidence, hiding evidence, suppressing evidence, because it's against the law. You can't do it, okay? And when you get caught, there's consequences. And Mr. Erickson has been doing it since day one and continues to do it up till today. So this is the special instruction number 2. From the evening of the fatal crash of September 29, 2020, and for years thereafter, defendant Scott Erickson intentionally provided false and misleading information related to the car he drove on the night of the collision and his reasons for concealing information about the car, his car. Because Erickson's acts were intentional and inhibited timely discovery of information about the case, you may conclude that if Scott Erickson had provided prompt and truthful information, that would have been unfavorable to him. That's what happens when you do that. There's a consequence. But why else would somebody get rid of evidence? Why else would somebody delete text messages for 4 months or selectively delete? Why else would somebody bring a car, first of all, tell the police you're driving a different car. Then all the lawyers come, all the people that inspect the car, all the way to Las Vegas, and he sits there and he gives the fake car. Who does that? Who does that in our society? That is totally vile, contemptible. He's trying to mislead, prejudice the plaintiffs who are trying to prove their case. And he knew he was doing it, and he still did it. And who drives around with fake license plate? Criminals. Criminals do that. You heard the LAPD insurance fraud investigator talk about who does that. Criminals. And who continues to do it to this day? Mr. Erickson. It's criminal. It's also criminal to come perjure yourself on the witness stand. And he's admitted it repeatedly. I'm going to show you. He's made a mockery of this judicial system. And his lawyers put him up here, and he lies and lies and lies. And then they question him, he lies and lies and lies. And then I come back and expose more lies. It's a mockery of this judicial system. You can't allow it. It can't be continence in this society, in this community. It's not allowable. You can't come to court and lie and perjure yourself and break all the rules. You can't do it. There's consequences. It's a choice, and you've got to pay the price. So look at this. This is what Erickson, speeding and racing, fleeing the scene, presenting the wrong vehicle, cold plating. I mean, I'm flabbergasted about it. Who does that? Didn't disclose the total alcohol, lied to the police, lied about the vehicle he's driving, threatened Alexis Grossman. Remember, the son had to write him and say, please leave our family alone. Enough. And he's in the bushes. Now he denies that. But why did he run back there so fast? He was so concerned, he said, about the boys, but he never checked about them. Ever once. Then he said he's so concerned about Rebecca Grossman, never told anyone who he was. Stayed there for 3 hours. Called Clayton, called the agent, called the lawyers. Never once said to the police anything. Here's the fake vehicle. Fraud. And then what he said, is it used by people who evade being identified? Yes. Is it used in criminal activity? Yes. The Erickson's engaged in all kinds of criminal activity. Don't tell anyone. If you tell anyone, I'll ruin your family. Threatening a witness in the case. Threatening. What about their knowledge of this? Well, we know she had the prior speeding ticket, excessive speed, we put that on. We know she's at the driving school with her own monogram information, AMG Mercedes Laguna Seca, driving a vehicle 130 miles an hour plus. Okay, that's what she's doing. We know that she agreed that she knew that was very dangerous, involved the risk of serious injury and property damage. She knew that years before. And what did Mercedes tell us?
Did Rebecca Grossman also have to promise that she would not be under the influence of any legal drug that would impair her ability to understand or comply with oral or written directions regarding the use of the vehicle?
Yes.
And are these promises not to be under the influence of alcohol or drugs, illegal or legal? Are these promises that all participants in the AMG Driving Academy are required to make in order to participate?
Yes.
And are these promises required because Mercedes-Benz USA and the AMG Driving Academy wants to ensure that the participants don't become a danger to themselves, the instructors, and the other participants?
That's correct, yes.
She knew, he knew, and they still did it. And they did it, and it resulted in death. And 5 years and 3/4 later, they're still denying it. Then Dr. Peter Grossman, he testified. She's well aware of the dangers. Scott Erickson. Here's the top 20 lies of Erickson. There's 46 of them, but I got to pick the top 20. Lied to Detective Yulson about which vehicle he's driving. Lied about producing the correct vehicle. Lied multiple times on our penalty charge he was driving a 2007 Mercedes. Lied about the amount he drank. Repeatedly lying to protect himself from Rebecca Grossman. Withheld from the police that he went to Stonehouse and was drinking. Lied about how long it took to run back to the scene. Lied about not seeing Rebecca Grossman after leaving Huey. Lied about why he stopped running to the scene. Lied about seeing pedestrians in the area every time. Remember, he said, oh no, and then I had to read his testimony. Lied about whether the pedestrian warning signs were present and clear. He said they were, then he changed. Lied about Royce Clayton telling him to go to the police multiple times. Lied about anything blocking his view, pitch black, racing and speeding, Peter and Rebecca being separated. I love that one. I played the testimony of him saying, no, Peter, he gets on the stand. He says, oh, it's not true. Did you just hear him testify? I wasn't listening, but he's sitting right there. Hopefully he's listening now. Lying about where he was when he spoke to the lawyer, lying about never discussing race with Royce Clayton, lying about being familiar with the area, and lying about threatening Alexis. That's just some of his lies. Look at this. Look at this.
Is that true? As you sit here today, you deny any responsibility or accountability whatsoever for the death of Mark.
Takes him 10 seconds to answer. Watch.
Yes.
His conscience is trying to tell him not to do it, but he couldn't because he always overrides. Remember I said, well, you were standing there when the fake vehicle and you knew it was a lie. Yeah, I knew it was wrong, but you still did it. Yeah, I still did. How about this one?
The question is, did you admit on that witness stand that you were lying to protect yourself and Ms. Grossman from responsibility and accountability? Yes or no?
Yes. Admitted lie.
Every time you lie, you're trying to protect yourself and Mrs. Grossman from accountability, reliability, and responsibility, correct?
Compound.
Yes. He's admitted it. He's lying to do. He's admitted it. Perjury. How do they get up here and say he's not responsible? Look at this one.
Are you proud of coming to court lying?
No.
Well, what? But you keep doing it, right? But you keep doing it, lying, even though you're not proud of it to protect yourself, right? Overruled.
Yes.
Did you know it's against the law to lie in court, though?
He knows it's against the law and he continues to do it. How can he be believed about anything? Okay, come on. How about this one?
Did you ever tell anyone, sir, that that was the car you were driving when Rebecca Grossman hit and killed the 2 children?
No.
And you had no problem withholding that information, right?
I knew it was the wrong thing to do.
So you knew it was the wrong thing and you still did it intentionally, right?
Yes.
So you knew something was wrong and you still did it. That means you intentionally deceived the parties on the evidence in this case. Isn't that true?
Yes.
I mean, really? Come on, ladies and gentlemen. This can't be allowed to go on. They can't come to court, admit they lie, to protect someone, and then get up here and say they're not responsible. This has to stop here, now. See some more from Mr. Erickson.
Do you have any idea, can you estimate how many messages related between you and this person?
Hundreds.
That testimony that you destroyed those messages that you knew were relevant to protect her and you from responsibility in this case, that is the truth, isn't it, sir?
Has to answer.
Yes.
He admitted he destroyed hundreds of messages, hundreds of pieces of evidence in this case. And then they're going to go up here and say, well, you can't prove they were in the chase. Well, we got all these witnesses who are there in the race. And then he destroys the evidence. Who does that? Who does that? Was there any, like, oh, yeah, you know, I'm sorry, whatever. He destroyed it intentionally. He lied about it. He continued to lie about it, and he's still lying about it. This is not acceptable in a court of law in anywhere, in this county, in this city. You can't do that. You can't. There's a law that says when you swear, I swear to tell the truth, the whole truth, and nothing but the truth. And he gets up here and lies and lies and lies. And there's 2 dead young boys, and the family is left in rumble. And this, they still cannot accept anything. No responsibility. None. And you're the only ones, ladies and gentlemen, that can make them accept responsibility. Because they're never going to do it on their own. Because they're entitled to do what they want to do. I'm a Major League Baseball player. I'm the plastic surgeon wife. We can do what we want. I can drive when I want because I know when I'm drunk. I decide when I should drive, Mr. Erickson. Told he got convicted in Nevada, said he's not supposed to drink and drive, he still does it. I mean, he don't get it. They don't get it.
And when the officer said, tell me everything, you withheld that you had 2 drinks, correct?
Yes.
And you again were trying to protect yourself from any liability in this case.
Yes.
I mean, I'm going to save some of these for later. I mean, for my rebuttal. I got so many of them.
So you would agree that the volitional act of traveling 73 to 80 miles an hour in an area that's frequented by pedestrians, walkers, families, dogs, to do that after consuming alcohol would be in conscious disregard of the rights and safety of pedestrians. Over.
Yes.
He just admitted punitive damages right there. The conscious disregard. He admitted it. I'm going to come back to these because I only got a few minutes left and I want to finish by noon.
And you know that's against the law to come into court and take an oath to tell the truth and lie and lie and lie. You know that, don't you, sir?
Yes.
And you know the jury has to assess the credibility of witnesses, right?
Yes.
And somebody that lies all the time, you would have a hard time believing them, wouldn't you, sir?
Yes.
He wouldn't even believe himself. Why should you? So here I think you should check both boxes, punitive damages. Malice oppression on Rebecca Grossman, malice oppression fraud on Erickson. Then we're going to come back and get down to those issues. all right? So I'm gonna finally talk a little bit. I'm gonna be done at noon. And I know I put up a lot of money to be awarded for compensation. Compensation tries to even out the losses. There's no bringing them back. And there's so much evidence. You saw it, it was emotional. But we didn't only put on really 4 witnesses about it, 5 witnesses. We didn't put on as much as we wanted because I think you had enough. But enough is enough. You got the point. But so what I did, and it's gonna be about 6 minutes, is there were 2 songs that were in evidence, Jacob and Mark's favorite songs. One was a spiritual song, and one wasn't. And then I took the exhibits, all are in evidence, and I put them together. And some people say that a picture's worth 1,000 words. Well, this video, and this is worth 1 billion words, because I could not do it justice. So I'm gonna play this, I'm gonna sit down, and I'm gonna be done. Then after lunch, they're gonna come and make all their arguments how they're not responsible. And then I get to come back briefly and respond, and the plan is it's all gonna be done today. Okay? So let me play this, and I'm gonna sit down. And I thank you for your time. Oh.
Bless the Lord, oh my soul, oh my soul, worship his holy name. Sing like never before, oh my soul, worship your holy name.
From the beginning of time, you know, I can't even hear it. Snakes don't have allergies either. Straight. Look at the cross. Say it. Now repeat after me. Our Father, who art in heaven, hallowed be thy name. My name is Jacob Iskander, and I'm going to show you how you do something the Jacob way, and also known as do something awesome. How we ever get so far down? How's it ever gonna turn around? So I turn my eyes to heaven. I thought, God, why don't you?
Come on, are you ready?
Yep, let's go. Hi, I'm Mark Iskander, and I'm doing your comedy act. Remember, I made all this joke myself, so I won't be offended if you don't laugh at me. But nobody was.
Fish.
Who's your favorite brother? Who's your favorite brother? Being a Christian is a favorite function. God takes you from the path into it and washes off all the dirt. Then you remove the seed of doubt, hate, and greed, and puts his light inside of you to shine for all the world to see.
And I don't see how anyone can say that a crosswalk that takes 70 steps to get across, 70 feet to get across, where you can't see the crosswalk around a bend, how anyone can say that is safe without a stoplight, a push button, pedestrian push
Excuse me,
button.
there's no theory
stoplight.
of that and no evidence in this case.
Because he's saying you're disregarding comment.
You heard about all the complaints about that people were having difficulties. You heard from Ms. Wilson. And you even heard when Mr. Corwin was here and Mr. Wessel, they both talked about, yes, there was a complaint in 2012. They recalled that. So there was 8 years between that complaint of people having difficulty with traffic not yielding to do something about it. And remember that 2012 episode, there was actually one 1 month before this accident. Mr. Wessel talked about that. And remember, I asked him, did you tell the city council about that? And he said he didn't. He didn't even pass it on to the city council. So yes, there were other things going on at the same time. The condition of the crosswalk was a big factor in the fact that this accident happened. Now, so much has been presented to you by the plaintiffs is speculation. Whether Ms. Grossman was intoxicated, we're going to look at the details that came in about that. And I'm going to point out what all the medical people did say about that after they looked at the results. You also heard that speculation that Ms. Grossman was trying to flee. We're going to talk about that. There is no objective evidence of any of that. It's speculation. People looking and saying, oh, I think this or I think that. Nobody got inside her head. Same for racing. It's speculation. And we will talk about what each of those people saw and whether or not they actually had personal knowledge of any of that. Now, Ms. Grossman didn't testify, and you cannot hold that against her. There's a right not to incriminate oneself, and that was one of the jury instructions His Honor read for you. So when you go into the jury room, that cannot be a consideration. So again, all I'm asking of you all is to review the actual evidence based on facts, not speculation. And you will decide. You are the deciders of the facts in the case. That's what your job is. Not my job, not Mr. Panish's job, not Mr. Braun's job, your job. Plaintiffs did not prove all the elements of their case. Ms. Grossman did not see the children as her attention was diverted to Ms. Iskander, who was diving out of the way just 2 seconds before the impact. She didn't flee the scene. There was zero evidence of that theory to support that theory. At the scene, you can see the location of the vehicle is pulled to the side of the road. And that wasn't done by Mercedes. It was done by the driver. She was the one who pulled it over. Although the fuel cuts off and the power brakes cut off and the power steering cut off, she's able to steer it, and she steered it and parked it at the side of the road. And you heard from Mr. Castaneda. He said that there was about 40 seconds, but after impact, from the time that he believes the car was actually stopped. That's hardly enough time to recover from an airbag hitting you in the face, an airbag hitting you in the feet, trying to figure out what's going on, and planning a strategy to escape. And she wasn't racing. This is all speculation. And the issues with the city, the cars blocking the signs. I think I showed you a few of those signs. You couldn't even see pedestrian sign ahead or the speed limit sign ahead because cars were parked there or trees were there. We'll talk about that. Or the speed limit sign ahead because cars were parked there or trees were there. We'll talk about that. Or the speed limit sign ahead because cars were parked there or trees were there. We'll talk about that. Or the speed limit sign ahead because cars were parked there or trees were there. We'll talk about that. Or the speed limit sign ahead because cars were parked there or trees were there. We'll talk about that. Or the speed limit that are being made in this case. Dr. Grossman is in the case only as the owner of the Mercedes that Ms. Grossman was driving. Nancy and Zachary have no claims against Rebecca and Peter Grossman. Karim Iskander has a claim for wrongful death against Rebecca Grossman on his behalf and as a successor in interest to Jacob Iskander. Nancy and Karim Iskander and their successors in interest, Jacob and Mark Iskander, and Zachary have claims against Mr. Erickson. Now, Ms. Grossman and Mr. Erickson are separate defendants in this case. There are separate defenses, separate allocations of fault, and the court did give you an instruction about that. Each of these defendants gets a separate consideration. And I think that's important because you should not connect Ms. Grossman's conduct to Mr. Erickson's conduct. Anything that Mr. Erickson may have said does not apply to Ms. Grossman. And I think that's very important.
I'm going to object. This is a misstatement of law number one. Number two.
Sustain.
So this is a civil action for damages. Dr. and Ms. Grossman do not blame Mr. and Mrs. Iskander for this accident. And this is something that I want to clear up, and I think it's very important. Because Mr. Panish told you,
Excuse me, Your Honor.
Mr. Panish told you in opening statement that the Grossman defendants were blaming Mr. and Mrs. Iskander for the death of the boys.
Just, Your Honor, that's fine. It opens it up. I can go back into it then. That's fine. If she wants to go that way.
Stop.
It was not true.
Stop.
No, strike that.
Stop. The objection is sustained.
This is a civil case for damages, and defendants have a constitutional right to put up a defense. The jury instructions will provide you with the basis upon which you decide damages. Anger should have no place in your decision on this case. The court has instructed you that damages to punish are not appropriate. So I want to put up the juror oath again. I know you all had it and you took it and you agreed to it, but at the time, you were probably a little bit in the state of shock of having been suddenly put on this jury that was going to take forever. And so it's worth looking at again. Do you understand and agree that you will carefully consider the case being heard in this court and that you will reach a verdict based only on the evidence presented to you and the instructions on the law given by the court? If you agree, please say I do. And you did. Another thing I want to talk about now is the relationship between Dr. Grossman and Mrs. Grossman. First, let's clear up one thing. As I said in opening statement, Dr. Grossman and Rebecca Grossman have been married for 26 years, and they decided to separate. Now, Peter Grossman testified, and you saw his testimony. They had not filed for divorce or legal separation, and that was true. But no question was asked of him as to whether or not they had informally separated. as many people do. And at the time of this accident, they were separated.
There's no evidence of that.
You're disregard those comments about what other people might do. Objection
The
sustained.
decision was not to get divorced, but to be separated.
There's no evidence.
Objection sustained.
Counsel,
You're
this is-
disregard those comments.
Now I want to talk about the impairment allegations. Ms. Grossman was not driving impaired at the time of this accident. Let's start at the beginning. At the beginning, the evening began at the Hare's residence. You heard from Mark Hare. And he told you that Ms. Grossman had a margarita between the hours of 4:30 and 5:30, and it may have only been half of a margarita. He testified that he made the margaritas himself, one for Cindy and Rebecca, and the drink had tequila, lime juice, tequila mix, and I think we have his clip that he testified.
Made everybody one drink, and Rebecca, that I saw, only consumed half of it at the point that I last looked at her drink, which was probably 15 minutes before she finally left.
So 15 minutes before Rebecca left, Mr. Hare saw that she still had about half of her margarita left. So there's no evidence whether she finished it or not. So that's the beginning. Now, we also know that Ms. Grossman had a margarita between 5:30 and 6:50 at Julio's. The accident occurred at approximately 7:09. No expert has testified that Ms. Grossman was impaired at the time of the accident at 7:09. And all of the experts agreed, for example, that the field sobriety test tells you the level of impairment at the time of the test. It doesn't go backward. It tells you at the time of the test. Let's talk about the field sobriety test. We all saw the video, and I'm just going to let it play a little bit while I talk to you. It took place about an hour after the accident, and you see Miss Grossman had a hat on, and she took it off, and she had her hair in pigtails. It was a subjective test that everyone could reach their own conclusion. That was a testimony of Mr. Kelly, Detective Kelly. And Detective Kelly also agreed that mistakes were made and that Detective Takis had opinions with regard to the way the test was done and that it was not done properly.
The standard field sobriety tests that you administered here, do you believe there were things that you could have done different or better during your testing?
Yes.
And have there been criticisms about, the directions you gave on the FSTs or the administration of those tests?
Yes.
So Deputy Kelly did not conduct all of the required tests. There were some tests, remember, that were required. There were some that were optional. He missed one of the required ones, and he gave several that were optional that are not considered validated tests as he described them. Now, Deputy Kelly also knew that Ms. Grossman had asthma because she told him that at the time.
It's no evidence.
He testified to it. And he had her blow into the breathalyzer, I think I counted 9 times. Deputy Kelly agreed that the failure to administer a standardized test can compromise the validity of the test. But he also said that even before he gave the test, he saw no loss of mental or physical faculties before the testing. He agreed that Ms. Grossman was coherent, that she had fair coordination, she had no slurred speech, and did not recall an unsteady gait. Any of those things, none of those things pointed to intoxication. And she answered those questions, true?
Yes.
And up to that point, would it be fair to say you had seen no loss of mental or physical faculties?
Correct.
Would you agree that her coordination was fair
Correct.
and she was coherent?
Correct.
You did not observe any unsteady gait, is that correct?
Not that I recall.
You did not observe slurred speech, correct?
No sort of speech.
Okay. Now we put a timeline together just so you could see. You can compare the timelines here. It started 7:09 is with the time of the crash. 8:15 is the field sobriety test over an hour later. 8:32 you have the first PAS test, the breathalyzer, and the second one at 8:35. And the results of those are on the chart there, 0.76 and 0.75, both being below the legal limit. And that was an hour, a little more than an hour, close to an hour and a half for the second one after the accident. So we heard from Ms. Meneses. Recall that Ms. Meneses was a toxicologist, and she talked about both the Valium and she talked about the alcohol. She agreed that the preliminary alcohol screening, the PAS, only shows the alcohol concentration at the time of the screening. It doesn't say at the time of the accident, and there's a difference for that because you go into absorption. Meneses agreed that the field sobriety testing only tells you, the jury, what the level of impairment existed at the time of the field sobriety test. So for each one of those time frames there, that is the result at that moment in time. It doesn't tell you the result at the time of the accident. Now, Ms. Meneses, Detective Takas, and Ms. DeCluse all agreed that the field sobriety test and the PAS results only show impairment at the exact time of each of those tests. All three of them agreed with that. So, moving on to the hospital. At the hospital, remember Ms. Grossman saw Dr. Matero, and he did the screening test. He spent time evaluating Ms. Grossman. He testified she seemed like she had good mental capacity to answer medical history questions. He evaluated her walking twice, and she was not limping and was able to walk with a steady gait.
And she seemed like she had good mental capacity to answer that, so I did see her walk twice while she was there, and she was not limping. I was able to walk with a steady gait.
All of that supporting that there's no intoxication. Now, also at the hospital was Sergeant Barraza and McGee, Officer McGee. And Officer McGee and Barraza were with Ms. Grossman the entire time, except for the short time that Sergeant Barraza had to go and get a fax for the blood test. And that's important because nothing could have happened that would not, by Ms. Grossman or to Ms. Grossman, that would not have been observed by a witness. And in that case, 100% of the time, it was Officer McGee. Now, Ms. Grossman had the blood draw at the hospital, and Sergeant Barraza was present for that. The blood was drawn at 10:17, so that's over 3 hours after the accident. And Sergeant Barraza agreed that Ms. Grossman was never alone at the hospital, and that she or Deputy McGee were with her the entire time. Now let's talk 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 with her the entire time. Now let's talk.
True. And so here, the 6.64 nanograms, that's 94% less than your reportable amount.
It's much lower, yes.
Yeah. And 6.7, your reportable amount.
It's much lower, yes.
Yeah. And 6.7, your reportable amount.
It's much lower, yes.
Yeah. And 6.7, your reportable amount.
It's much lower, yes.
Yeah. And 6.7, your reportable amount.
It's much lower, yes.
Yeah. And 6.7, your reportable amount.
It's much lower, yes.
Yeah. And 6.7, your reportable amount.
It's much lower, yes.
Yeah. And 6.7, your reportable amount.
It's much lower, yes.
Yeah. And 6.7, your reportable amount.
It's much lower, yes.
Yeah. And 6.7,
eliminate. And there, all of those same witnesses testified there's no accepted method to calculate the absorption rate for Ms. Grossman. Ms. Meneses agreed that if someone is still absorbing alcohol and had not yet reached peak, then earlier in time, the blood alcohol concentration would be lower than at peak. And Meneses admitted she could not determine Ms. Grossman's exact blood alcohol at the time of the accident. So we still have no evidence of impairment. I want to talk now about the issues of speed, the allegations that Ms. Grossman was speeding. This argument stems mostly from the EDR. So there are some issues with the EDR that I need to bring to your attention. The first one has to do with there are data limitations. And the use of the EDR is not intended to provide specific information regarding data interpretation. This is what Bosch and Mercedes publish on the EDR itself. And I think you saw that during the testimony. So that's the first thing. And plaintiff's expert acknowledged that some of the readings on this EDR don't make sense, but they can choose to rely on the rest of, they choose to rely on the rest of it anyway. So they don't rely on some of it that doesn't make sense, but then they rely on it when it comes to speed. So for example, one of the issues deals with the average operating miles. The EDR showed, the EDR
Is this an evidence?
This is a demonstrative.
No, there's no evidence of that. You can't put that on your final argument.
That's okay, I can just say
Objection
it.
sustained.
It's-
Objection sustained, you're at disregard, that last.
Well, you all saw the EDR, and I will just tell you what the numbers said that you saw. The numbers said that the EDR, that the vehicle mileage was 67,990 kilometers. And if you convert that to miles, that comes out to 42,247 miles. Now, the EDR said that this was the miles over the operating time. And the operating time is provided in the EDR. It says it's 4,461 minutes. So if you convert that to hours by dividing by 60, you get 74.35 hours. So you have 42,247 miles over 74.35 hours, which is 568.21 miles per hour. That's impossible. that the average speed of the vehicle would be 568.21 miles per hour. But that's what the EDR tells you. And the experts were asked about this, but no one commented on an explanation for it. Most of them just ignored it. The other thing about the EDR that we heard about was ignition cycles. And you might remember that. It started out early. Well, that's just my drafting of the ignition cycles. You recall that there was testimony by Mr. Hale and Mr. Castaneda that by the time Mr. Castaneda did his download, the increase in ignition cycles was 117 from the time of the crash. But remember, Mr. Hale, Detective Hale, came in here early. He was like the first witness, first or second witness, and he came in here and he said, well, those 15 that came on before the first download, you have to blame those on Ms. Grossman, because we think that means she was trying to start a car to get away. Well, if that's true, then why does the vehicle continue to add more and more ignition cycles when no one's driving it? And there's no explanation for that. There's nothing about that explanation Mr. Hale gave that ties this to Ms. Grossman's conduct other than pure speculation. They accused her of trying to flee based on the fact that the vehicle has added ignition cycles. And there's another point that wasn't explained about the ignition cycles. And that was, we know this vehicle was a 2018. And if we assume it was owned for that entire time, about 34 months, that's about 1,035 days. Now the EDR recorded 54,584 ignition cycles in that period. And if you do simple arithmetic, you're going to figure out that that would come out to starting your car. If every single time an ignition cycle came up, that somebody is manually starting the car, that would mean that you started your car once every 27 minutes around the clock for nearly 3 years. You just have to do the math to get that. Nobody's explained that. So either the EDR is not properly representing ignition cycles because there's something wrong with it, or ignition cycles don't mean somebody is manually starting the car. It means something else. The car is picking up ignition cycles for some other purpose or from something else. So the EDR itself, which is the basis of the opinion that has been given about speeding before the accident, it's insufficient all by itself for the basis of the opinion to conclude that there is speeding. And the experts knew this, so what they did was they made calculations based on assumptions. They worked backward from what was a known speed. Remember, we saw the speeds after the accident from the boathouse video and the videos that actually captured, and they did frame-by-frame analysis, and they figured out the speed. So they had a known factor of speed there and worked their way backwards, making assumptions and calculating it to try to get it to match the EDR. So, for example, the EDR doesn't give you all the information you need in order to make that calculation. The EDR doesn't tell you what time the crash was. So you don't have a figure for the amount of time between the time of the incident to the time that you first have them on camera after the accident. So that was an assumption that had to be made. And they made that assumption and calculated backwards to get it to match the EDR. So the EDR cannot by itself be the tool that is used to convince you that Ms. Grossman was speeding. There's another issue too with the EDR. And remember the delta V, the whole argument about delta V, the airbag is normally not something that goes off when a pedestrian is hit, but it did go off in this case. So why did it go off? Usually the airbag has to have a certain delta V to go off, a change in velocity. In this case, remember the delta V's change in velocity was negative number, negative 1.2. You remember that? It's not enough to make the airbag deploy. And so Hale knew that, and so he made an assumption when I asked him that. And he said, well, I think that the airbag deployed because one of the boys hit the sensor. But he never did any kind of an analysis to show you that. He just says it, and he doesn't show anything that proves that that actually happened. Mr. Castaneda did not adopt that. He did not come in here and tell you that one of the boys hit the sensor. He had a different explanation. I don't know if you remember. He said that he believes the EDR went off because of a jerk. I don't know if you remember that. He did a whole analysis about the jerk factor, how you have to have, it's not just delta V, it's delta V over time. And then I asked him, so how much of a jerk do you need? How do you quantify that? And he said he would have to guess. The jerk analysis, for lack of a better word, do we have any way to quantify what that was that would trigger, in your opinion, the airbag deployment? Answer, well, I think we'd be kind of guessing. So remember, I had to impeach him with his deposition because he wouldn't repeat the same thing on the witness stand, and that was me reading from his deposition. Science is not guessing. Science cannot be based on speculation. The only accurate, trustworthy evidence regarding Ms. Grossman's speed comes from the videos that we see after. And we know that it's trustworthy because we can see the time, we measure the frames, and all of that work was done for you. And the speed after the accident was 50 to 52 miles an hour, according to Mr. Castaneda. And Mr. Castaneda did admit that EDR data can be inaccurate.
EDR data can be inaccurate.
So, Ms. Grossman's speed for 52 miles an hour is consistent with the traffic studies for that roadway. Remember, the roadway was designed for 55 miles an hour, so 52 would be a reasonable amount. It's a little over the posted speed limit. So now I want to talk about Ms. Grossman did not see the children in the crosswalk. This was one of the things I told you I thought the evidence was going to show.
Isn't this issue decided?
Sorry, continue.
Yeah, thank you. We know that after the accident, Ms. Grossman made a call to Mr. Erickson. Remember, you heard about that. Something horrible happened. And then he said something along the lines of, did you see the kids in the road? And she said something like, oh, kids, and hung up.
This is
Jesus. Jury's recollection of the evidence will control.
Well, you heard it. If I've said it wrong, then you remember what it was.
Well, you heard the evidence.
Yes, exactly. Okay, so that suggests that she didn't know what she hit. She didn't see the kids because she didn't say, I hit the kids. Something horrible happened is what she said. And also we heard from Detective Mejia, or Deputy Mejia. And Ms. Grossman told Deputy Mejia that she was driving and that she hit something. You recall that testimony?
And when you arrived at Ms. Grossman's vehicle, did you speak with her?
I did.
Did she tell you she was driving the white Mercedes?
She said she was driving, and she said that she had hit something.
She had hit something. She didn't say what it was or that she knew what it was. None of the plaintiff's experts analyzed what Ms. Grossman could see as she approached the intersection. Nobody did that analysis. And the sheriff's investigation didn't do an analysis of that either. Now, we heard from Mr. Hale And his testimony doesn't prove that Miss Grossman could see the kids either. You've never visited the scene, true?
True.
Your opinions do not take into account the adequacy of signage that leads up to the crosswalk. Is that true?
Yes, that's true.
And it's true that you did no assessment as to whether the boys could see the approaching cars at any point, correct?
Correct.
And you also made no assessment of whether the drivers could see the signs that were indicating that there was a crosswalk ahead, correct?
Correct.
Well, you don't actually know the speed that children were traveling, do you?
I know they were traveling the speed that I used or greater,
You made an assumption, right?
based on the fact that they were walking. Yes, I didn't know at the time that they were on rollerblades and scooter.
So you made an assumption, correct?
Okay.
So Mr. Hale gave you the opinion that Ms. Grossman had been, if she had been driving at 45 miles an hour, the accident would not have happened, but he didn't know what the actual speed was that the kids were moving. And he also didn't know whether or not they stopped along the way, if they stopped in the middle, if they stopped at any point when their lawn fell over. No, but he didn't do that kind of an analysis. So without knowing whether or not Ms. Grossman actually saw the kids, the law does not ask a driver to react to something that they can't see. And Mr. Hale agreed that she would have to see the pedestrians to know that she should stop or yield. She'd have to know they were there. Her attention was diverted to Ms. Iskander, who was driving, Ms. Iskander, who was diving out of the way of Mr. Erickson's vehicle. And Mr. Castaneda said that it was about 2 seconds after Mr. Erickson's vehicle went through the crosswalk at the time of the accident. So if you use the EDR, if you decide you believe the EDR is accurate, and you recall that on the EDR, she had tapped the brakes, recall that? And it was at minus 1.5 seconds. If it was about minus 2 seconds from the impact that Ms. Iskander was diving, that would mean about a half a second later is when we see on the EDR that the brakes are applied. Did she see, was that because she saw Ms. Iskander diving and she hit the brakes? And if it was for that reason, that would tell you a couple things. It would tell you that she didn't see what was in front of her because she saw what was on the side of her at that moment. And it would also tell you that she reacted to what she did see with falling aside really quickly, which would be consistent with not being impaired. All right, so I want to talk about the accusation that Ms. Grossman tried to flee. There was really no evidence on this. The only things that you have been told have been based on speculation, what people who were not in her head said, for people who saw vehicles from different locations and what they decided that must all mean. So first of all, we know that her airbag went off and the chemicals came into the airbag, from the airbag. The car activated its emergency response system. It cut off the fuel and the power, steering, and braking. The car shut off does not take control of the vehicle or steer it or brake it. So Miss Grossman had to do that. She's the one who hit the brakes to get to the side of the road. She's the one who steered the vehicle to the side of the road, and you can see it actually parked.
There's no evidence of that.
It's the same. You're going to disregard that.
Well, we know that it wasn't done by Mercedes. We know that it wasn't.
There's no evidence of that.
Yes, there is.
No.
Okay. So At 50 miles an hour, which is the speed that Mr. Castaneda said just after impact, the car would have coasted to a stop much further away from where it is that she ended up parking. At the scene, we see the car pulled over, and the vehicle stopped, according to Mr. Castaneda, about 40 seconds after impact, which is, as I pointed out before, that's hardly enough time to form a strategy that you're going to somehow flee and get away. So we know that the airbag would have caused her to have some delay. But the other thing that's important here is that she was on with the dispatch of the fire department. And you remember, you heard that she was told to stay with the car, and that's what she did. We also heard from Deputy Gadet just the other day, and he responded to the call, and he saw her, and he had her at the side of the road with a police car behind her at 7:10. So that's about a minute, less than a minute, depending on which part of the minute it is. 7:10 from the crash. So she's already pulled over. She's not fleeing. She cooperated with the officers. She cooperated with Officer Barraza and Officer Kelly. They both testified to that. And we already talked about the ignition cycles. The ignition cycles don't prove fleeing. Now, it is interesting to say here because initially Mr. Hale came in here and said, oh, I think the 15 initial cycles means she was trying to flee. But did you catch that he also explained why, in general, ignition cycles increase? So if there were no other downloads, then the ignition cycles should not have been more than 54,585, which would be one more download. True?
Or it's possible that there could be another couple if whoever's doing the download is having a hard time getting the car to power up. That does happen from time to time. Every once in a while, the car may be powered up to assist in getting it on a tow truck. Sometimes that happens. And like I said, there are other reasons why you may see additional ignition cycles.
So Mr. Hale actually knew that there were explanations for the ignition cycles. Mr. Castaneda also knew that there were explanations for the ignition cycles. So you have no explanation for all of the increased ignition cycles. Isn't that true?
Well, that's not necessarily true. If we start with the vehicle at the crash site, at some point in time it's going to lose power, or at least it's not going to be mobilized. There could be ignition cycles that are going to be gained in efforts to try to get the car to start. And that could be done by multiple individuals. And that could include Ms. Grossman, that could include investigating officers, that could include people that are towing the vehicle, people that are going to be transporting to a secure yard. These are things that are going to happen in an effort to try to gain power to, say for example, disengage the lock for the steering wheel. Things of that nature, just to get the vehicle to move free and clear, and to get information from the dashboard as well.
And so we put a little bit of a timeline chart here so you can see. We know that the airbag deployed, the vehicle automatic fuel cut off, the engine disabled the braking, engine disables braking and coasting. Engine disabled, sorry, and she is braking and coasting. And Ms. Grossman remains with the vehicle as instructed by the fire department dispatch. We know that from the evidence. So the evidence does not support, the evidence does not support that Ms. Grossman tried to flee. Let's talk about Ms. Grasso, because we heard the council mention Ms. Grasso. Remember, she was the technician, I think the ER tech at the hospital, and she made a claim that Ms. Grossman told her she would be home in her garage if they didn't disable her. Well, first of all, the statement has no credibility, and you'll be able to decide whether or not you believe that statement was made and whether it's a true statement. First of all, the Mercedes didn't disable her vehicle, nor did anyone else. The airbag module automatically cuts off the fuel. Ms. Grossman herself would have been able to drive the vehicle over at where it was parked. But second, and more importantly, is Ms. Grossman was never alone at the hospital. Detective McGee or Deputy McGee was present with her the entire time she was there. And he did not recall Ms. Grossman making the statement. And Sergeant Barraza was with her all the time except for when she went to get the facts. She did not recall the statement being made. And here's another thing. If the statement had been made and Deputy McGee had heard it, we would have seen it in one of the reports. And nobody testified in the report that it was there. Now, I want to talk a little bit about, well, actually, yes, we have the witness credibility instruction that His Honor has given us.
Counsel, mind your time.
I'm sorry?
Mind your time.
How am I doing? How much time do I have, Your Honor?
9 minutes.
Yep. Okay. Anyway, so the court has given you that instruction. You heard from witnesses that said that Ms. Grossman was racing, and I want to talk about that. Mutart, who you heard that was played earlier, he wasn't there. He doesn't know. He's repeating what somebody else said. Mortensen, Privichel, Curry, Sands, Eftihari, and Iskander all were speculating. I will tell you, Morgeson was a mile from the intersection, and he was on Lindero, and he had testified in his deposition that they were only light-colored cars. And remember, Mr. Harrison had to impeach him by reading his deposition into the record, where he had said he only saw white SUVs racing. He didn't see a black SUV. Frigitil, Mr. Frigitil, he was over a mile away, and remember, he said he heard engines revving. If we can put that map up. And this is the map from him, and you can see that, may I approach her?
Yes.
I'm just gonna go quick. Julio's is up here, and the engines revving were over, I think they're right over here. You have a dock for that? Where did it go? There it is. This is where he heard the engines revving. But Ms. Grossman and Mr. Erickson didn't take that route. They came down this way. So that couldn't have been their vehicles over there. You couple that with the 3 white cars, and it's not their cars. Pamela Curry, she said, and you heard her, she said she saw 3 white cars. She did not say she saw a black car. She was sure about it. And remember, she was the one who said she looked in the window and she recognized Ms. Grossman. But she didn't recognize Ms. Grossman, she said, until she saw the news broadcast. And then she said that she recognized her looking in through the passenger window to the driver, and that she saw her sandy blonde hair. Well, she had a hat on and she had pigtails on. So I'm not sure how she could even see her hair through all that. That'll be up to you to decide whether you think that's credible testimony. Okay, I'm going to go straight now, because I'm running out of time, to the city, because that is very important. The city knew about this dangerous condition for years. They ignored it. They put it on. It was important enough that citizens complained that they put it on the city council agenda, not once or twice, but several times. And you heard all that testimony. People were having incidents, near misses, but the city said they weren't going to do anything about it. Why? Because, as Mr. Dunlap said, as Mr. Wessel said, as the 2 city managers said, didn't matter, because there hadn't been an actual hit. No pedestrian had been hit. So they were waiting for a pedestrian to be hit in order to make a change.
There's no.
And that
evidence
is
of
not proper. That's what they
There's no
said.
evidence of that.
They said they were not going to do anything because there were zero. You remember Mr. Dunlap said, you can't do better than zero. And there were 0 pedestrian accidents. And so the pedestrian count was 0. They weren't going to do anything. You can decide what you think that means with regard to the city. Let's stop a moment and just think for a second about what the situation would have been like if there had been a different arrangement at the crosswalk. If the Iskander family had pushed the button.
Excuse me, Your Honor, this is not a theory. It's improper, again, argument by counsel.
Objection sustained.
Okay. All right, I need to talk a little bit about the damages. I'm just going to go right to that. First of all, the issue of punitive damages. The test has to be clear and convincing evidence. And how can you have clear and convincing evidence if the evidence is based on speculation? It has to be, you can't be a guess. You have to know, yes, this is proved by clear and convincing, not the feather. It has to be clear and convincing. And the instruction, by the way, doesn't say anything about 75%. Clear and convincing. And you have to decide. And I would submit to you that there is no evidence that Ms. Grossman was racing. The actual evidence of the intoxication didn't pan out. She was under the legal limit. There's no evidence that she was impaired. And there's no evidence that she was, well, no evidence that she was racing or any agreement to race. And that's the other thing. When you see the instruction for racing, you have to have an agreement to race. What evidence did you see that Ms. Grossman formed an agreement with Mr. Erickson that they were going to race? There was no evidence presented on that. You can't just assume that there's 2 cars, because 2 cars are going to the same location. And even if they're driving fast, that doesn't mean racing. There was no evidence that Ms. Grossman was racing. And I want to talk just really quickly about the numbers. And first, I want to talk a little bit about allocation of fault. I believe the city's involvement is significant. It's at least as much as Mr. Erickson and Ms. Grossman. They had the ability to make the intersection safe. And we believe that had they put a cross light there, the accident would not have happened.
Excuse me, Your Honor, again.
It's an argument.
How many times could she do this?
Objection sustained.
The city was on notice of the problem, no question. And they made a decision, a conscious decision, to ignore it. So we don't minimize the loss at all in talking about damages, but respecting the loss does not mean accepting a number that is not tied to the loss. And this is not an auction or a celebrity contract or a painting for sale. And plaintiff compared these damages to the prices for those items. He compared the damages that he believes that the Iskander family should have to the price of a $435 million painting. And I don't know if you totaled it up, but the damages that he put up were $439 million. That's almost $500 million. He did that because he wanted to make the hundreds of millions feel normal to you, to attach it to something. But your verdict has to be based on evidence and the law and a reasonable compensation. And I would submit to you, that is not a reasonable compensation. So we ask that this case not decided on grief or anger or labels. We ask that you honor the commitment that you all made to follow the law and to return a reasonable verdict based on the evidence. No number can measure their lives. The law recognizes that. There's no instruction that can ask you to value a specific person's life. And the question is not, what is Mark and Jacob's life worth? You can't do that. There's no price tag on a life. But it's your decision for you to decide what you think is reasonable. And that's all I can say right now. Mr. Panish will have another opportunity to get up, and I hope that when he does, that you will think about, what would I say in response? Because you have the evidence. You've heard it all. We presented to you as best that we could, both sides. And thank you very much.
Good setup.
Could do your own.
All right, so we'll take a break. Do not talk about the case amongst yourselves or with anyone else. Try to keep it right at 5 minutes.